Hello, everyone, and welcome to another episode of Court Watch. How's everyone doing? Hope your Thursday's going well. Let's see what's going on in chat. Hello, Phoenix2250, Nemesaur, Terradona, Freylines, Rinty, Dillis Filler, Ken's Sister Sue, Harold Elbleman, Jay's a Proxy, and everyone else I didn't get to. How's it going? Let's see. Phoenix2250 with a 25 stream streak says, I never know what to say with these things, but I parasocially love you in chat. Back at ya. Lucas Dawn with a 360 stream streak. Very nice. And I think that catches us up. Cool beans. Today we have a particular litigant that's quite interesting. If you watched the last Sovereign Citizen watch, he was the last video we watched because he's sort of Sovereign Citizen adjacent. I wouldn't call him a full Sov-Cit, but he is working in his own weird pseudo-legal sphere of his own. This is a gentleman who has been declared a vexatious litigant, so he can't be his own attorney, and he can't file lawsuits without an attorney. Of course, the videos we're watching today are prior to that, so that's fun. We're going to see him freak out a lot. This first court case that's going to be the first thing we talk about was during COVID, and he continually refused to wear a mask to go into court or to use their online portal. So this case took a year and a half, even though it probably should have taken about 6 months, if that. So that's pretty annoying. I did cut out like the half a dozen or so videos where they had hearings and he didn't show up because he wasn't allowed in without a mask, because that happened a lot. Broha, thanks for 52 months. So anyway, let me get to my housekeeping and then we'll get started. If you're on YouTube, do me a favor and hit the like button. Hello, Neon Talons, welcome. If you hit the like button, the thumbs up, it helps new people find the stream. I appreciate it. You can also hype the video on YouTube, which helps it get discovered by new people. On Twitch, if you want to help support the stream, you can always become a subscriber, gift subs, or bits. It is close to the end of the month, and we're pretty close to our sub goal, so consider gifting subs if you want to help support the stream. Other than that, we can just jump right into it. I pulled up a bunch of videos today. I guess we'll see how many we get through. The playlist from our Nevada judges on YouTube has upwards of 60 court videos on Kim Blandino. He finds himself in court a lot. But I looked through and I found ones where he's at least in them, because of course there are many hearings that are about him, but I wanted to focus on him. So, without further ado, let's jump into it. This particular court case, which is the state of Nevada versus Kim Blandino, is about him intimidating and extorting a judge. The actual charges are extorting a judge and I think impersonating a state official. He basically was pretending to be someone affiliated with like a judicial oversight committee and telling the judge that he needed to pay him money and to give like a public apology because that judge had ruled against him previously. Not a smart thing to do. So anyway, let's get into it. Wannabe66, thanks for a 7-stream streak.
Nevada versus
Yeah, I was working yesterday, Wannabe. It's unfortunate, but, you know, that's the way of things.
Blandino, case C341767.
Hats off. Sweet Lily Love, what do you want me to wear for the hats off? Which hat? Okay.
Will the
Good morning. Good morning, Your Honor. Mike Dickerson on behalf of the state. I apologize. For some reason, my video is not working today.
Okay, no problem. Counsel, will you make your appearance?
Yes, Your Honor. Ben Bateman, bar number 9338. I am standby counsel for the defendant, Mr. Blandino.
Did he have intimidation charges? I don't think he was actually charged with that. I think I said that because he was definitely intimidating the judge, but I think he was specifically charged with extorting a judge and, they'll say it in the videos at some point, impersonating a state official or something like that.
Wearing a mask, he cannot come in.
I've got a religious exemption. I've got a...
Wearing a mask.
This is one of... He gets kicked out immediately. This is just to illustrate how shitty he is about the mask mandates at the time. He also refused to use their online portal because he claims he needs to see everyone's faces to get feedback. So, yeah, he's just really difficult.
Blandino, I've got a medical and religious exemption. I've got an application to the U.S. Supreme Court on
If
this
he's not
matter.
wearing a mask, he can't come in.
All right, Mr.
Put some
Blandino.
plexiglass up.
Mr.
You've got to look
Blandino.
for do alternatives.
He's not wearing
I
a mask.
object.
Let's go, Mr. Blandino.
Noted.
I object.
Okay.
I object.
I don't know. Okay.
You're not objecting. You're ejected. They're very different.
I know.
And I would just note for the record, Your Honor, that this is the second time that we've had a hearing held in this case where the defendant has come to court and refused to wear a mask and then caused some scene as a result.
Okay, I know that the state has filed a motion. I feel like this is a motion asking the court to follow the rules of evidence. I obviously will follow the rules of evidence. He didn't have an opportunity to file any opposition, so I'm going to deny this without prejudice since it doesn't ask me to exclude any.
I will say about this judge, I think that she's way too soft on Kim Blandino, and I think she was the same judge that let Chili off his charges and reversed his conviction. I could be wrong.
Specific evidence that obviously.
Oh wow, these subtitles are really wrong. Are they set to the wrong language? Yeah, this happens sometimes. It auto-detected and thinks that it's Romanian and it's translating to English. Hold on. Where are just the English ones? Why? What? What is YouTube doing? It's not Romanian. It's English. Okay, I'm just gonna turn them off for now, because they're not helping.
I'm going to be careful about what can come in and what cannot come in, and I won't let him go into anything that's not relevant.
Okay. Yeah, our main contention in it is essentially
She's the head judge of Clark County Court, so she oversees a ton of appeals. I see.
that we don't want him to try to turn it into a trial about everything that he's done in his life to try to hold judges accountable anywhere in the county or in the world for that matter. I think that defense, as well as Mr. Blandino and the court, can just anticipate that we will object to anything outside the scope of this particular case.
Okay? Thank you. And thank you for your parents' counsel.
Thank you, Judge.
Page 13.
Yeah, no.
And that's the end of the first video. Here's the next
State
one.
Nevada versus Kim Blandino, KC 341-767.
I think this is another one where he doesn't show up.
Good
Morning, Marilyn. Oh,
Yes.
Melanie Marlin for the state.
Statement, counsel for Blandino.
Is standby counsel present on the blue jeans?
Yes, can you hear me?
Yeah.
They gave him standby counsel for this case, too, which eventually became his lawyer because this is the case where his pro se status gets revoked.
That's better. Okay, it's my understanding that Mr. Blandino presented again this morning. He refused to wear a mask. He's been given an opportunity to appear by Blue Jeans. I don't know why.
Blue Jeans is the name of the online software they use to what do they call it? To call into court via video chat.
He won't appear by Blue Jeans.
And for the record, I did have a telephonic conversation with Mr. Blandino this morning, informed him that he did need to wear a mask. He declined to do so for religious reasons, so that's where we are today. I've talked to Mr. Bateman, informed him that we need to get a USB drive from Mr. Blandino. We have additional discovery. I just want to make a record of that.
Okay. And also, he dropped off some documentation, so I will be marking this and making part of the record, and we will set for trial, and he's in invoke status.
I want to point out, reminder, I have cut out the vast majority of the videos where he does not show up because of the mask mandates. He does this like 6 to 9 times. I watched those videos, so you didn't have to. It pretty much goes the exact same every time. You know, he doesn't show up, he refuses to get on the telecom thing, and they just continue it. At some point, the prosecution starts asking for a warrant because he's effectively choosing not to show up to court. Eventually, he does start using the Blue Jeans software, which is good, I guess, but he's not happy about it.
Yes. And Judge, if I may, just Mr.
Am I the court-stalgia critic? I relitigate it so you don't have to.
Blandino, I did speak to him prior to the hearing today. He did want me to remind you there are 2 outstanding motions he has pending, as well as the outstanding discovery. So if I can just make those representations.
What motions does he think are outstanding? There's
I
one.
believe-
He's filed another emergency motion to disqualify Judge Bell. That's pending.
I think in this case he files about 16 or 17 motions to disqualify the judge, any of the judges in this particular district. It gets denied every single time, but he keeps filing the same motions over and over, expecting different results. It's pretty crazy. It's one of the reasons he loses his right to be his own attorney, because frankly, he's a vexatious litigant. He just keeps clogging up the court with nonsense.
I don't know what else he thinks is pending.
Yes, the motions to disqualify.
He's a control freak. Artie's Corporate Fiction did a deep dive on his legal history. It's insane. Oh yeah, he kidnapped his children in the 90s after his wife divorced him and said that she had a spiritual cancer and she was dead. She's not dead. He was lying and kidnapped his children.
Okay, and what else?
And I believe he also has a motion in federal district court to address the mask mandate, is what he mentioned this morning.
Okay. All right. So we will set it for trial.
Calendar call is going to be October 6th at either 8:30 a.m. or 10:15 a.m. depending on the pandemic. Jury trial, October 12th, 10:30. And I'll email him in a minute.
Okay, and Mr. Blandino has been given an opportunity, like everybody else, to appear by Blue Jeans. There are several parties, attorneys, and district attorneys appearing by Blue Jeans, but apparently he does not want to take that option.
All right. Here's the first time he actually shows up via Blue Jeans. He is on the bottom here. He's in the red shirt with the little sign behind him that says Blue Lives Save or something. And he's going to talk when he shouldn't.
This is a mic check. Say Excelsior if you can hear me.
Why Excelsior? Is he Stan Lee?
Hi, Mr. Blandino. You don't have to check
Excelsior?
in. Okay.
Someone did say it. Okay. Is this still try? Okay, it's English again. Good. There's the subtitles back.
I'm not good at this technology stuff.
I'm not good at this technology.
State of Nevada versus Blandino, KC 341767. Who's here for the state?
Mike Dickerson on behalf of the state, Your Honor.
Thank you, Mr. Dickerson. Mr. Blandino, will you please state your full name?
I'm Kim Blandino. I'm appearing pro se only by special appearance. I have Chris Cave next to me. He's a witness and assisting me at counsel. Ben Bateman, I don't know where he is. I'm in Ben Bateman's office. I don't know this technology stuff, so therefore I'm using Ben.
I don't know this technology stuff. I am turning it up. I don't understand this excuse in the 2020s. Computers aren't newfangled devices. They've been a core part of working and living for like 20 years. Like, imagine if you just met someone who was like, I don't know these newfangled doors. And you're like, what? And they're like, I just don't know how to... People come in and out of them. I see them do it. I don't understand. Like, at a certain point, it's your fault for not learning how to do a basic thing everyone needs to know in order to survive in the world.
Bateman's technology here in his office.
Thank you. And then, Mr. Bateman, will you make your appearance?
Yes. Yes, good afternoon, Your Honor. Ben Bateman, bar number 9.
Ooh, now it's way too loud.
338. I'm standby counsel for Mr. Blandino.
Okay.
Ironically, I'm at the RJC.
And he's
Stone Corbell says, as an IT person, I don't understand this tech stuff. Does not put me at ease. It just makes me stifle an annoyed groan.
your office? Okay. But the
Yes,
rest
I've
is
got a
correct.
sentencing in Department 18 I'm waiting on.
Yeah, that Mr. Blandino did appear today via Blue Jeans. I know the state has this motion on regarding
I need
bail.
to interject, Judge. I'm sorry,
Oh,
but
you
there's a
don't
motion to
know.
disqualify.
Stop talking.
There is a motion to
Rude.
disqualify you. You have no
Blandino,
business sitting on
stop.
the bench.
Mr.
Unless you
Blandino,
transfer.
stop talking.
It gets to the point where, like, everyone in the court is annoyed with him and tells him to shut up. Like, there's literally a point when this actually does go to trial. We're not going to get to that video today because we have so much else to get through before that. But at one point, his lawyer literally, I think, tells him, like, shut up. Because he's trying to argue, and Blandino keeps butting in.
Who's saying stop talking? Who's saying stop?
Everybody is.
The court is
Everybody
telling you
is.
to stop talking. She is trying to talk to you, so let the judge speak.
Hey, I know that the state has filed their motion.
Chitara says, whoa, what jackpot have I stumbled upon? The courtroom ones are my favorite, and this is gold.
The state filed their motion.
You can thank our Nevada judges for uploading all of this, by the way. They're the same people that covered Chili DeCastro's trial from a couple years ago. They cover all sorts of court cases in this particular district of Nevada, and they have tons of playlists. So if you're into court stuff, definitely check out our Nevada judges on YouTube.
The state filed their motion on March 8th, and then, the state filed their motion, and then a couple days later, Mr. Blandino filed a motion to disqualify. And so therefore, I'm going to vacate today, and I will put it back on for after April 15th. He's also.
If there's a record being made, I need to make a record. Judge,
You thought they did all of Nevada? I guess it's possible, but I only really ever see videos in this particular district. I'm sure they have others, but that's mostly what I've seen.
Why he's even talking. Let's just go a date after April 15th.
That continuance is going to be April 21st. Or, I'm sorry, it'll be April 22nd.
I can't hear that. Can you speak louder?
The continued date for the state's motion is going to be April 22nd at
You ever watch a TV show and they write a character to be so annoying and everyone's annoyed by that character intentionally? He's like that in real life.
12:30.
Is that April 22nd at 12:30?
That's correct. Thank you.
I can't make any record here.
Page 13.
We're done with your case, Mr. Blandino. Have a good day.
Jesus Christ.
Versus Kim Blandino, KC 34176.
This is actually a longer hearing. This one goes on for 52 minutes. Oh, did we F? What is going on? Are we back? Man, that's been weird. Now YouTube's been better than Twitch lately. That's so weird.
Make your appearance.
Anyway, what I was saying was, I feel bad for the prosecution here, Michael Dickerson, because he makes, like, many, many motions to try and rein in Kim Blandino, and the judge, like, doesn't accept any of them. It's kind of crazy.
Okay, how's that?
Perfect. Go ahead. You can make your appearance.
Kim Blandino appearing pro se by Blue Jeans. They won't let me in the courthouse without a mask, and so I can't wear a mask, and that's why I'm appearing here. Necessity.
We don't need to hear why.
Thank you. And Mr. Bateman, do you want to make your appearance?
Yes, good afternoon, Your Honor. Ben Bateman, bar number 9338. I'm standby counsel for Mr. Blandino.
Okay, thank you very much, and thank you very much.
Right off the bat, there is no way you can proceed forward. Tiara Jones has an unadjudicated motion to disqualify against her that was filed.
Mr. Blandino, I am going to proceed, and if you interrupt me, then I'm going to have the clerk mute your microphone. Okay?
I object to you.
I am going to proceed. You can object. I understand. You object to me proceeding over this. I got it, and the record will reflect that. So the first motion, the state's motion to remand the defendant or order additional conditions of release. Mr. Dickerson, do you want to be heard?
Yes, Your Honor. Thank you. So this motion was placed on calendar back in February of 2021 based upon the defendant sending the state
2020?
2020. The state sending...
It's been about a year and a half.
That's correct. The state sending the defendant sending the state a letter indicating extremely concerning things about him going to the named victim's home as well as municipal.
I object. It was a discreet distance.
Okay,
Not to his
Mr. Blandino, you can speak after.
Sure, I went to the judge's house, but it was a discreet distance, so it's okay. I stalk, but from afar. Therefore, it's okay.
Interrupt the district attorney. If you proceed on interrupting people when they're talking again, I will mute your microphone. Mr. Dickerson, you may proceed.
Thank you, Your Honor. The defendant sending this letter to us indicating he's going to visit the named victim's home as well as another judge's home and pretty much indicating in there that, hey, guess what? Looks like I'm no longer on high-level electronic monitoring, so I can do what I want, and the condition of no contact does not apply. I would...
That's a genius move. As soon as you get off house arrest, telling the victims in your case, guess who's not on house arrest anymore? That's not probably the best trial strategy. I don't think that makes you look very good to the judge.
Suggest
It's also pants on head crazy.
That since it has been such a long time, without a doubt, the court should, at the very least, make sure that it is clear that the condition of having no contact with the named victim, and I would also submit as well as any other sitting judge or pro tem judge in Clark County, since obviously that's the basis of what he's indicating here during the time of his release on this case. That would be at a minimum.
Okay, and so I know that the initial no contact order was asked to Mr. Federico. Is that correct?
That's correct, Your
Mr. Federico is the judge that this is all about, that he extorted.
Honor.
And then I thought there was another judge that I guess presided over a TPO hearing, and that judge was a temporary judge as well?
The Shannon Nordstrom is a judge.
I should say he's a judge pro tem, so he's only a judge like part-time. He's mainly a lawyer.
That the defendant has become fixated on over the years, and that's who he was indicating within the letter, that he was going to also go to her house to conduct some sort of surveillance upon her residence.
Okay. All right. So the state is seeking to just make sure that he understands those conditions?
Yes, Your Honor.
Okay, Mr. Blandino, do you want to be heard?
Okay. Again, I got to renew my objection. I'm only speaking. You don't have the capacity to move forward, but since you're forcing me to move forward, and I got to defend myself against illegal acts, namely you sitting on here when there's an motion.
Listen, Mr. Blandino, I'm not gonna go through this every time you have an opportunity to talk.
Well,
You filed about 4 motions
She pretty much does put up with it.
to disqualify. Each and every one of them have been denied. I have jurisdiction, and we're going to proceed. So if you want to talk about this specific issue, you may.
Okay,
Go
I'm
ahead.
going to have, because they're trying to do something illegal here, and they're lying again on the record. I said that I would maintain a discrete distance to view that home, which would be any discrete distance that would normally be in a temporary restraining order or a protective order. The thing is that it was subsequent to filing a suit, which I have now filed. The court can take judicial notice.
He seems to think, by the way, that if he files an appeal or a lawsuit about this current case to a higher court, that they have to stop all proceedings immediately, no matter how spurious these motions or court cases are. It's really ridiculous. That's basically what he's saying right now is, actually, Judge, I have appealed to a higher court than you, and I said that you aren't allowed to be on my case in my filing, so you need to wait until I win in federal court or in a higher court. And it just doesn't work like that, especially when you're known for being a vexatious litigant and filing nonsense constantly.
Filed a federal suit against Michael Federico for abuse of process.
He's trying to sue the victim in his case. He's suing the judge that he's in trouble for extorting in the middle of the extortion trial.
I have a responsibility filing the suit to investigate, to see if there's anything regarding that. But in absolute truth, and I state this under penalty of perjury, I have not visited Federico's home. I'm not visited Nordstrom. It's in light. The reason I sent this.
They said that you sent a letter saying you were going to. They never said you went there. The threat is enough. You can't threaten the victims in your case.
And it's not really a trial balloon, but I sent this notice to Mr. Dickerson and to the other parties in that note, was to see if there was any fuss made about it. And I got the ankle bracelet to prove it. I haven't been anywhere near those persons. And the court doesn't have to make any conditions. I just say I'm not going to do that until that's resolved. But the point has to be that Judge Bell, when I got back from LCC, over my objections, against my will, I said that you can't really do, you're competency court judge, and you can't really do conditions of custody. But she's nonetheless said, dropped it from, she knew it was high level before. She said, I don't think that's necessary. She put it on medium, and she didn't set any other conditions. I double checked that with my house arrest officer, Daniel Webb, and he said, Kim, there's no conditions on you whatsoever. And I said, well, I'll still let you know when I'm going to a sensitive area, like to the municipal court or whatever, because at municipal court I could run into these people, Federico or Shannon Nordstrom. And I object to Mr. Dickerson's characterization that I don't know how you put it, didn't say obsessed with Shannon Nordstrom. I've got a file, and my statute of limitations is running off on that. Both of these people, Federico...
I'm not obsessed. I just have a file on them. There's a difference.
And Nordstrom filed frivolous temporary protective order requests with the Justice Court, and they were denied outright. We did have a little hearing on Shannon Nordstrom and with Jansen on the...
This is completely not related, but I hate that fish picture behind him. That's an ugly-ass picture of fish, and I don't even dislike fish. I don't like to eat them, but they look fine. Tropical fish look good. How do you make fish look so bad in a painting?
The Federico one, he did that. So they've abused process. Federico, their complaining witness, lied and perjured himself. And as a matter of fact, Dickerson and Melanie Marlin were...
I don't think that any of this is relevant, so I'm going to stop you right there. I am going to deny the state's...
Peeplord with 40 bits says, working on a fanfic, can I get your thoughts on a hypothetical implanted GPS tracker GLP-1 smart release device being given to folks in a Hunger Games scenario? Basic idea is starving without hunger allows for more sober thinking about how you got to the Hunger Games island in the first place. We all know what island. Oh, God. Jesus Christ.
Motion to remand you. I'm going to allow...
I don't know why I read the nonsense insanity that you send, but thank you for the bits.
Allow you to stay on house arrest. However, I disagree that there were no special conditions. At no time was that no contact order lifted. So I just want to make sure you understand you are to have no contact with Mr. Federico and or Miss Shannon Nordstrom. Do you understand
Federico.
that?
Yeah, there's Federico. No first R in there. It's not Federico, it's Federico.
Okay, thank you very much. Thank you for correcting me, Federico. Okay, and so Mr. Dickerson, you can prepare the order on that. And then
So,
now there's a...
It's just to stay away from Federico and Nordstrom.
Stop talking.
That is correct.
Okay.
That is correct. I do not believe that the no contact order was ever lifted. So, Mr. Dickerson, I think the next motion, let's see, the state's motion regarding his self-representation.
That's correct, Your Honor. As you'll recall, this motion was originally filed back in November of 2020. And at that point in time, it was heard, the court in December 17th of 2020 essentially held the motion in abeyance and indicated that
is the Coke a good vintage? It tastes better in a glass than it does if you're drinking out of the plastic bottle. I don't know the physics behind it, or rather chemistry, probably just drinking a lot of microplastics, but it tastes better. Tastes more like Coke.
Weren't going to grant it at that time. You were going to wait and assess how the defendant behaved going forward in this case. The state has since that time filed 3 supplements.
What about a glass bottle? Those can be good. I like the glass bottle Cokes, especially if they're the ones from Mexico that use actual cane sugar. Because, like, the Coke we have in America, it's made with corn syrup. So it kind of leaves, like, a weird film in your mouth, and it's gross. The one made with cane sugar doesn't do that.
To that motion, detailing every time the conduct that the defendant has shown throughout the course of this particular case and outside of this case as well. That includes what we'd previously been discussing of the letter that he sent to the state indicating that he's going to go conduct this covert surveillance upon the victim and municipal court judge Nordstrom. In addition to that, after that January 2021 letter, we have a series of motions to disqualify that have been filed. That begins March 8th, 2021. That is what I've called in my moving papers the 3rd motion to disqualify, or the 5th motion to disqualify. April 14th, 2021, the 6th motion to disqualify.
Again, by the end of this case, he files 17 or 18 motions to disqualify the judge.
22nd, 2021, the 7th motion to disqualify. May 6th, 2021, the 8th motion to disqualify. May 18th, 2021, email to your court staff that was extremely disparaging. August 10th, 2021, Judge Wilson issued his order denying what he termed the 3rd motion to disqualify against you, Your Honor. He also indicated within his order that all of these motions that the defendant had been filing were in fact illegitimate, and they were only filed to gain a tactical advantage. This and goes on to my analysis of the abusive process that the defendant has continued to show during this time that this state's motion to revoke his right to self-representation has been held in abeyance. And so we filed this 3rd supplement to the motion to revoke his right to self-representation. We filed that on August 13th, 2020. In there, you see that I've also...
Phoenix asks, did you 30-somethings do that experiment in school where you eat things with different colored dyes and see how it affects your perception of flavor, even though there is no flavor added? For instance, purple tends to make people think there's grape flavor. I don't think I ever did that in school, but I did. Do you guys remember the Heinz purple ketchup? I remember being excited for the Heinz purple ketchup, and then I was very disappointed. And the green one. So I kind of accidentally did that experiment as a kid by buying a product that turned out to be gross.
So indicated under Indiana v. Edwards, the extreme concerns that we see as far as the defendant's diagnosis of having a personality disorder, specifically a personality disorder that includes obsessive, schizotypal, and prominent narcissistic traits. Looking to the...
Imagine getting called out on your personality disorders in open court.
Mayo Clinic's definition of what that entails, we all get an idea of exactly what is going on here and what the problem is. You see that a personality disorder is an rigid and unhealthy pattern of thinking. And then from there, getting into the typology of his personality disorder, we see exactly why he continues down this path of the abusive process and refusing to acknowledge orders of the court, specifically the order of Judge Wilson, which has already indicated that his filings were illegitimate, because his response thereto is then in the next days, August 18th, 2021, he then files his 9th and 10th motions to disqualify, including a motion to disqualify all of the district court judges in the 8th Judicial District, which was
You can't prosecute me if I dismiss all the judges. Checkmate, court.
specifically referenced by Judge Wilson in his order as being one of the bases for him determining that these were illegitimate motions.
You're shocked he didn't interrupt to correct them. I'm almost wondering if he's muted at this point, because I can't believe he didn't speak out during the personality disorder thing either. That's like a lot.
That he was filing. And then to go further, a few days after that, August 23rd, 2021, as of yesterday, he's now filed his 11th motion to disqualify. This is a continuing abusive process that the defendant is going to continue down. We are in a position right now where it has become clear. It's become clear under Ferretta that the plain terms of the U.S. Supreme Court's seminal decision on self-representation provides that this does not provide a right to abuse the dignity of the courtroom. It does not provide a right to avoid compliance with the relevant rules and procedural and substantive law. And it does not provide a right to engage in serious obstructionist misconduct, which is exactly what the defendant is doing. And case in point, when we started off this hearing today, the defendant, after...
You think they could revoke his right to self-representation? Eventually they do. Eventually this gets difficult enough that they take his standby counsel and make them his actual counsel.
The court, having issued minute orders denying his motions to disqualify, begins this proceeding today by saying, Your Honor, you do not have jurisdiction to hear this case, cannot proceed today, because it evidences exactly what he has been doing. These are his obstructionist misconduct to delay this case and file these motions only for a tactical advantage to achieve that delay. Based upon that, I think he's left this court with no other option but to revoke his right to self-representation, because he continues to abuse the process, and it's clear that he's going to continue from this point forward.
Okay. Are you done, Mr. Dickerson?
I am, Your Honor.
Okay, Mr. Blandino?
Okay, well, he's lying through his teeth again. Really unfortunate.
Objection, Your Honor. He's a liar.
Fortunate that he violates his own code.
Mr. Blandino, I am not going to permit you to call the attorneys or anyone a liar. I just want to hear what you want to say in opposition. Do not make disparaging remarks about the district attorney or anyone else involved. It's not appropriate.
Well, would you prefer the term of candor? Is that appropriate?
No, I don't want you to say anything to the district attorney. I want you to oppose the motion.
What did they say? Which disorder he has? Is he formally diagnosed? They didn't specifically name the personality disorder, but I assume based on previous cases he had, including the kidnapping stuff of his kids, he may have had some sort of evaluation by the court, and that might just be on the record. They didn't say specifically, but they said he has very rigid thinking, he has narcissistic personality traits, stuff like that.
In fact, Judge Wilson did not say I did. He said he was concerned that Mr. Blandino thing, and he used the term concerned to gain a tactical advantage or to delay the. But the thing is, Mr. Dickerson misleads the court when it says 10 motions to disqualify. This is one of the main factors into which I went into investigating judicial corruption and misconduct, especially in the 8th Judicial District Court. The court does not want to follow NRS 1.23.
Again, I should clarify that one of the things that he is on trial for in this case is misrepresenting himself and impersonating a public official that's like investigating the judiciary. That's one of the things this trial is over, and he's still trying to claim it.
3-5. They want to make the law up as they go. For decades now, they
At least he's not naming the specific organization, because in this case, there was a specific actual judicial oversight committee that he claimed he was, what was the phrasing? It was like voluntarily associated with, which like means nothing. But he was trying to imply that he, in some official capacity, was working with a judicial oversight group. And he's not. He just isn't. Stone Corbell says, do you think he knows he's the most annoying person in the universe and that's his deliberate strategy, or is he totally unaware of it? I think he is unaware of it. I think he thinks he has a brilliant legal mind because he says that sometimes. He thinks he's smarter and knows the law better than all of these judges, and he thinks he's here to clean up the courts. He's a complete narcissist.
They don't follow, when the motion to disqualify is filed, only a challenge can be brought within 5 days. If the judge decides that they're not going to challenge the motion to disqualify, it is their obligation to immediately transfer the case. And then the thing is, if they do file a challenge, it's supposed to be by a party, heard by a party agreed upon by the parties, and if they're not can't come to an agreement, then by a judge appointed. But the 8th Judicial District, trying to become its own legislature, in essence says, no, we're going to have the chief judge hear all of these motions to disqualify. So it's been Judge Bell, now the current chief judge. Before that, it was Judge
Blandino, or do you have anything?
Who does he want to hear his case? He says any judge outside of this district, but he would just do the same thing in the next district. I think he's just trying to get so many judges disqualified that they just throw the case away, which of course doesn't happen.
That you want to say in response to the state's motion? They're asking me to revoke your self-representation.
Every one of these motions to disqualify have been based on facts and evidence that Kim has that he cannot have a fair trial by any 8 Judicial District Court judges. This judge can, as you can take judicial notice of in the Marlon Brown case, I am going to have to call multiple judges as witnesses. And in the Marlon Brown case...
that has nothing to do with this case. If you don't...
I want to point out, too, at some point he asks to call himself as an expert witness, which is pretty funny.
Want to talk about this particular motion, I will just rule on the plea.
To be clear, to be a witness yourself, sure, but he wanted to call himself as an expert witness. If you don't know the difference, a normal witness can only testify to what they have directly seen or witnessed. An expert witness, on the other hand, is like someone that comes in that has expertise in some specific field, and they are allowed to give opinions or speculate to some degree about things that fall under their expertise. This is like when a scientist comes in to testify about some sort of, what's the word I'm thinking of? Some sort of like DNA testing or whatever, you know, or... in movie terms, if you remember in My Cousin Vinny at the end, the one character testifies about her knowledge about automobiles. She's allowed to speculate and give her opinion on things because she's an expert witness. He basically just wants to go on the stand and be able to say whatever the fuck he wants. Which, of course, you know, he can't. There are rules.
But it is very clear to me that, you know, you do not want to follow the rules. You don't want to follow the rules. And you continually, you know, do this obstructionist behavior and try to impede and obstruct the state from moving forward. You were able to obstruct the state from being heard on their motion to remand you for over a year based on these motions to disqualify.
How could I forget Marissa Tomei? I did forget her name. Sorry.
It's not right. If you don't want to follow the rules, I'm going to revoke your self-representation. I want to make sure you understand. Self-representation is not absolute. If you do not comply with the rules, I will revoke your self-representation. You will be appointed an attorney, and your attorney will litigate this case, not you. Do you understand that?
Well, I'd like you to point out to me, Judge.
Do you understand that?
rule did I not follow? I don't know. I'm the one that followed NRS 12301.235, and at no time did Judge Wilson state that my motions
His poor standby counsel is so tired of this.
to disqualify were frivolous. He said it was to gain a tactic.
They are not made in good faith. I believe that you filed these last motions to disqualify to prevent the state of Nevada from having their motions heard, and you were successful in preventing them from having their motions heard. And then when it gets back on calendar, even though your motion has been denied, you simply file another one.
Just go to this.
You stand outside the courthouse with
Judge.
Make the rules.
Sorry, there's a
I
break in
just
the middle.
follow the rules. And I'm not going to allow you to just simply disregard the rules.
Can I rebut? Yes, I got
I don't think he's talked enough. Absolutely.
from a doctor. I appeared on August 10th before the Board of Examiners with with the governor. I was 6 feet away from him without a mask, and he was no problem with that. This is on YouTube. The court can take judicial notice.
The fact that some other judge didn't enforce the rules that he was supposed to doesn't make it okay for you to break the rules in every courtroom. He's still talking about the mask mandates. Are you fucking kidding me?
I showed his staff this doctor's note, and he allowed me to make public comments twice, at the beginning and at the end, with this doctor's note that I cannot wear a mask. In addition to the
You will have
medical...
to appear via blue jeans. That's fine. I mean, you were appearing via blue jeans today, and that's fine. But for the last year, you have refused to appear even by blue jeans. And you stand outside the courthouse without a mask on, and you demand to be let in, and you have to be told you cannot come in. So again, I just want to make sure you understand. You don't want to wear a mask. You have a medical condition. I don't need to know about it. You can appear via blue jeans. That's fine with me. I have absolutely no problem with that.
I have a problem with blue jeans. I can hardly make out your face at all. I can't tell what's going on with your facial expressions.
You could just listen to the words she's saying. I know that's difficult for you because a woman is talking, but, give it your best shot.
Need to have feedback. I'm 60.
The feedback is negative at all times. There, I solved it for you.
6 years old in October, and I have problems.
I am not going to argue with you. These are the rules, and that's what you can do. Okay? It is what it is. I'm not going to let you just bypass the rules. You are not above the rules. And again, I want to make sure you understand, self-representation is not absolute. You have obstructed and impeded for over a year by your refusal to follow the rules. And then, when the state comes close to having their motions heard by the court, you simply file another motion to disqualify, even though for an entire year there's basically nothing going on. So again, I just want to make sure you understand, you are not entitled to ignore the rules. Your behavior is disruptive, and you obstruct and impede. If you continue down this path, I will revoke your right to represent yourself. Do you understand that?
Well, I understand what you're saying, but I respectfully...
She didn't ask if you agree with it. She didn't ask if you agree. She asked if you understand. So a yes or a no would have been completely appropriate.
I'm following the rules, and I'm following the statutes, and it's the...
Does he think that he'll see micro-expressions on the judge's face that prove he's winning if he's there in person? Again, he's very full of himself. I think he... How do I put this? I think he likes pretending to be a lawyer. He gets into, civil stuff all the time, or at least he used to before he got declared a vexatious litigant. I think he also used to give legal advice to people, which he isn't supposed to do. He likes to pretend to be a lawyer and give advice to other people involved in civil litigation. I think it's his little fantasy. He likes to go into court and pretend to be a lawyer, and it makes him feel big. It makes him feel smart. So I think it breaks the fantasy a little when it's just over this, like, you know, telecommunications app or whatever. He wants to be in court in a suit arguing, you know, like Perry Mason. He wants to be Perry Mason. He can't be Perry Mason on the internet. That's lame. Jitara with 50 bits says tearfully, Savi, you're going down a path I can't follow. And Angel of the Grove, thank you for 16 months.
The 8 judicial district court judges that aren't following the statute.
Okay. All right. Again, it sounds like you understand me, because I'm not going to allow you to continue to...
Maybe he's a little young for Perry Mason. Let's go Matlock. He wants to be Matlock based on his suits.
...make a mockery of the court system. Do you understand?
I understand what you're saying.
Okay, so if you continue with this obstructionist and impeding behavior and refusal to follow the rules, I will revoke your
Hugh Jassel says, how could I feel like Perry Mason? I'm not wearing pants.
Representation. Do you have any questions about that?
I don't hear any specificity on what you're just in a conclusory fashion saying I'm abusing the thing by filing these motions to disqualify. And contrary to what Judge...
Oh yeah, Perry Mason came back in the 80s too, didn't it? They did the original Perry Mason and then they did like a revival. So yeah, he'd know about Perry Mason too.
Wilson states...
Did you guys know I own Perry Mason and the revival Perry Mason on DVD? And the recent Perry Mason reboot that happened on HBO some years ago?
I am sincere that I don't believe I can get any kind of fair trial with any 8 judicial district court judge. And Marlon Brown was allowed to have all of those recused, and he had co-sach assigned to his petition for writ of habeas corpus.
Again, we don't think you have to follow the rules.
Not Blu-ray. Perry Mason isn't on Blu-ray except for the HBO series.
No.
So I just want to make sure...
Is that Coke or Pepsi? Coke.
You understand. So at this point, I'm going to deny their request to revoke your self-representation.
Can we come up with a court watch bingo card? That'd be pretty fun.
We
should.
I want to make sure you understand.
What about Ironside? I've never seen Ironside.
Understand?
Or LA Law, which I should really watch, because doesn't that have Shatner in it? I like Shatner. Not as a person, as an actor.
There is enough in this record right now for me to revoke your self-representation.
Have you guys ever seen Incubus? It's one of the only movies ever made completely in Esperanto, and William Shatner is in it, and he's terrible, and it's beautiful.
So if you continue down this road, I'm going to revoke your self-representation. So I suggest you follow the rules and that you stop with this obstructionist behavior.
No, that's Boston legal? Okay, never mind.
So the next one is, let's see.
Can I make one quick record on that, Your Honor?
You may.
The defendant misstated the ruling of Judge Wilson. Specifically, and I quote, Judge Wilson says, I conclude Mr. Blandino's disqualification claims are not legitimate, that they were made to gain tactical advantages in his criminal case before Judge Levitt. This is something the defendant needs to understand as he moves forward. It's clear today, listening to him, that he intends to continue down that path despite the...
Yeah, the judge needed to get him in line way sooner than she does. I feel, again, so bad for the prosecution because he puts forward many motions to try and reprimand Mr. Blandino, and she just lets it go on too long. Just a Peach with $1 tip says he's a little old maybe for Ironsides. Perry Mason and Ironsides played by the same actor. Oh, I didn't know that.
The court's ruling. So I just want to make it very clear that our position is he should still have his representation revoked today, despite the warning. Your Honor's found that there's the basis for it, that he's committed serious obstructionist misconduct. It's really just giving him another opportunity for another years-long delay based upon these continued motions to disqualify, which are illegitimate.
Oh, random hype train. If you want to help out the hype train, you can gift subs, become a subscriber, or use bits. Thank you.
Okay, well, I can assure you I will not let it go on for a year.
On that, Judge? So if
Let me see. This was August 24th, 2021. Let's see how much longer she gives him. Yeah, not a whole year. The trial happens in March of the next year.
I take this issue,
August, September, October, November, December, January, February, March. 7 more months, though. Sweet Lily Love with 100 bits says, enjoy some pro se bits. Thank you so much.
of the motions to disqualify, which now I have a factual record, because they're saying they're not a fact finder. So would I be not following the rules if I appeal this denial to the Nevada Supreme, not appeal, but by extraordinary writ? I mean, am I going to be charged with not following the rules if I say, I think you're wrong, and I think I need extraordinary relief? Because here's the order that they just issued. It said, as it appears that petitioner's motion to disqualify the district judge has been resolved, such that any motions concerning his house arrest and trial can now move forward, we conclude that our extraordinary intervention is not warranted at this time. So
that's a denial. That's a denial. Is he so narcissistic that he completely ignored that that's a denial specifically because it says at this time at the end? That's some narcissistic, like, world warping going on where you completely don't understand that they're telling you no? What? Let's see. If you're ever wanting to make one, I made a sob sit bingo with 81 spots and sob sits in the beginning of November. I'll definitely take a look at that. Thank you. Raymond Barry, thanks for a 3-stream streak. Normal Gamer Gal, thanks for 200 bits. And there's a hydrate. Will do. 55% to level 1 in the hype train. Midnight with 100 bits says, in honor of Kim Blandino, I vote we change the term Karen to Kim.
that means that now, that if you're with this record now, I need to go by extraordinary writ petition back to the Supreme Court and say, hey, look, you know, I've got legitimate things. Wilson says I didn't cite specific facts, but he didn't even cite Ripple versus State. That's the controlling law in this. I'm sorry, Ripple v. Baker, is that there's not actual or implied bias. There only has to be the risk of intolerable risk of unconstitutional bias.
And why you still haven't said why you think there's any sort of implication of bias whatsoever. You just don't like the judges. That's not a reason. The fact that you personally are afraid of them for no good reason is not a reason for them to recuse themselves. Stone Corbell, thanks for gifting a sub. Caesar Bishop with 40 bits says, everybody panic, oh my god, there's a bear loose in the Coliseum. There'll be no refunds. Your refund will be escaping this death trap with your life. If you have small children, use it as a shield. They love the tender meat. Cover your sodas. Dewey loves sugar. I don't know what that was about, but it was fun to read.
And I think I've shown that clearly. Okay. And so I think
all right, but nobody else does that has ruled on these motions. So again, do what you think is appropriate. But again, I'm not going to allow you to obstruct.
Oh, that was from Semi-Pro. I got to rewatch Semi-Pro.
These proceedings, because the state of Nevada, they're entitled to a fair trial and fair proceedings as well. So again, you've been warned. I think the record is clear. I believe I'm required to warn you that your self-representation will be revoked. I think the record is clear that I have made that warning and instructed you that I will not hesitate to revoke your self-representation.
And all of that's just going through one ear and out the other. He's frustrating. Stone Corbell, thanks for gifting another sub and getting us over level 1 of the hype train.
Stay of proceeding.
So the next one is, I'm sorry, what?
Can I ask for a stay of these proceedings pending my petition to the Nevada Supreme Court?
Denied.
On the motion to disqualify his issue. They said that they're at once you get
any request for a stay is denied.
Okay, can I get that in writing so that I've got the denial in writing?
First of all, I didn't grant any motion or order. But I'm telling you right now, there is no stay that is going to be issued today pursuant to anything that I'm doing.
Bumble Homestead, thanks for gifting a sub.
Your motion, Mr. Blandino. It's your motion for release from GPS monitoring.
I don't have a motion.
Do you have dates? Yeah, you do have a motion.
$5 tip says, it literally, the name on there is $5 tip says, thanks for all the entertainment, Hannah. I work in community health as a counselor and appreciate your insights and experiences. I think that was Venus World on YouTube. Thank you very much.
You want to go see your son Andrew in California?
Well, I didn't phrase that as a motion. I was just, that was a notice to the court.
And thank you for being a community health counselor. That's probably a stressful job, but that's good.
There's an emergency thing I need to do. And if I make a motion to you, it undercuts my argument that you could be fair and unbiased. I don't think you...
Okay, let me tell you something else. If you continue to refuse that this court has jurisdiction, then I will revoke your self-representation. Because in my opinion, that is continuing to impede and obstruct. You can say, I don't agree with Judge Wilson's order or Judge Bell's order or the other. I mean, it's been denied 4 times now. You can say you do not agree with that, and you can file an appeal and do whatever you think is appropriate, but you cannot continue to refuse to acknowledge that this court has jurisdiction.
Well,
do you understand that?
Then I think you're still there's a risk of bias. I want to see you resign.
Right. So your motion, and I'm going to tell you another.
She muted him. Oh, you think she's biased? We haven't heard it the last 80 times you said it.
You are not permitted to communicate with my office. All these emails, you have been told several times not to communicate with my office. It is inappropriate.
Oh my god, he's contacting the judge's office directly? That's not good. That's, why am I blanking on the term? Ex parte communication. That's not allowed. Green Guy with a $3 tip says, being able to do anything I want every day blows my mind. I went and picked up chips and dip. That must be nice. I hope you enjoy your retirement.
Communicate with my office. If there is anything that you feel like you have to communicate to the court, I ask that you put it in writing, send it in the mail, or have Mr. Bateman communicate with this court. All of these emails that you have been sending over here, I wasn't even reading them. I became aware of some of them when I read the state's opposition. And
minute left on the hype train. Harold Elbleman with the 55 stream streak says 55 streams. Also wanted to say nice things about Raymond Burr besides stuff, you know, from Wiki. Quote, he portrayed the suspected murderer in the Alfred Hitchcock thriller Rear Window, and he also had a role in the 1956 film Godzilla King of the Monsters, which he reprised in the 1985 film Godzilla 1985. He met his husband on the set of Perry Mason in 1960, and they opened and ran a vineyard together until his death in 93. Yeah, he played, oh gosh, what was Raymond Burr's character in that? Steve Martin in Godzilla King of the Monsters and Godzilla 1985. I like the Japanese version of Godzilla better, obviously, but I do kind of like those Americanized versions a little bit. They're different. They're different. Nemesaur, thanks for gifting 10 Tier 1 subs. Much appreciated. 88% to level 4.
Apparently, they've all been made part of the record. So the record will reflect. We have left side filed many emails that you have sent the court that are ex-parte communication. They are inappropriate, and an attorney would never be allowed to send those type of emails.
I need to respond.
Again, do not communicate with my chambers. There is nothing you have to communicate with us.
I need to respond to that, Judge. While there's a motion to disqualify pending, you are a party in that collateral action in which I have by statute the right to at the very least ask to have a judge that could hear that. And if we would have had a judge to hear this months ago, rather than trying to go through this Villani and then Jones and Alf and all this kind of thing over the years, if you had been able to agree, well, let's have a judge from another district, then we wouldn't have had all this. And I could have gone to the
blaming the judge for him impeding the court proceedings.
Nevada Supreme.
If you'd just given in to my childish tantrum, we could have been at trial by now, Judge.
Court quicker. So my position is that by you not following NRS 1.235 and to agree upon a judge. Bell was already recused. She
Okay.
put
And
that on the
again, I am talking about, again, this is kind of what you do. I am talking about don't communicate with my office. And you say you want to respond to that, and you say something completely
I'm saying how
different.
you're on the motion to disqualify. It's not inappropriate to contact you. The statute.
There is no motion to disqualify. And here's the thing I'm going to tell you again. Do not contact my office. Okay? Do not attempt to have ex parte communications. If there's anything that you need to communicate, you can put it in writing. You can send it to the court through the mail, CC in the other side, or you can have Mr. Bateman communicate with the court. But all this ex parte communication, I don't care what you think of me. So stop reducing it to writing and sending it to the court.
I object to ex parte. They were copied. The DA was copied. Everybody else was copied. So it's not ex parte because they were given knowledge of this, and they had.
I'm telling you, don't communicate with my office anymore.
Okay, that's
It's
fine, but it's not.
inappropriate. It's abusive and it's harassment. So you need to stop.
Yeah, the judge is wearing a mask. This was in 2021. Phoenix Leftist, thanks for gifting a sub and getting us over level 4 of the hype train.
Doing it. Okay? If you don't want me to hear your motion to release you from GPS monitoring, can you let me know that? Because it's on calendar for today and I was inclined to rule on it. But if you don't want a ruling on it, that's fine.
Oh, I'm saying I would be undercutting my own argument. There was no motion. I put it in, I think, as a notice and demand. And I've got an emergency.
So do you want me to take it off calendar?
Well, no, I don't. I'm not saying I want you to do anything there. I want you to resign from the case. I want you to resign from
What a dick.
the bench.
All right, Mr.
I'm kind of obsessed with looking at the standby counsel during his shots because he looks like he's regretting going to law school. You ever heard the song Don't Be a Lawyer? It was part of the show, what was that show? I don't remember the name of it. It was a musical show. Anyway, I feel like that's going through his head right now.
Mr. Blandino, I'm telling you right now, you're going to get your self-representation revoked before this hearing's over. I mean, it just appears as though you just refuse to follow the rules or accept that the court has jurisdiction. It is totally inappropriate to say what you just said.
Well, you said, you asked what I wanted. I want to have a judge that's unbiased, no risk of bias, that I can present a motion to be able to go visit my son. But I don't have that, and it would undercut my argument if I believe that you were unbiased. I believe you're still biased, and there's a risk of bias with
You keep ruling against me. There must be bias. I can't be incompetent.
you. So I can't follow. That's why I didn't put it in as a motion. You know,
That's fine. My misunderstanding. It was on the calendar today. So I will vacate defendant's emergency ex parte motion for release from GPS monitoring.
Wait a
And
minute.
I'll make sure the record is clear.
Wait a minute.
If there's any appeal to the Supreme Court, that I was willing to rule on this motion, and you said you didn't want the court to rule on it.
Directed to Judge Wilson. Judge Wilson did have the authority to do that. Or it was Gregory. It was
No, he didn't.
You don't get to pick which judge hears your motion.
Should look at the order appointing him. He did not. Okay.
It was either
Is there anything else? I don't think there's anything else.
There's 2 other motions on too.
Okay, but those are all defendant's motion. Oh, I also wanted to indicate that the reason why it took so long is that Mr. Blandino filed another motion to disqualify this court. Okay?
No.
Then it goes to Judge Bell. Then Judge Bell assigned it to Judge Jones. Mr. Blandino promptly filed a motion to disqualify Ms. Jones. Then when it went from Judge Jones to Judge Alf, he promptly filed a motion to disqualify Judge Alf. It was abundantly clear that it didn't matter who Judge Bell assigned that motion to. Mr. Blandino was going to file another motion to disqualify, and that's why she
Indefinitely delay your trial with this simple trick. Just a Peach with a $1 tip says, Law by Mike has talked to the standby counsel. I think he interviewed Kim Blandino after this trial, too. It's pretty interesting. Minute left on the hype train.
She sought guidance from Justice Hardesty in the Nevada Supreme Court to get a judge assigned to hear the motion to disqualify. So that is why it took so long, because Mr. Blandino kept moving to disqualify every judge that was assigned the motion to disqualify.
Which is consistent with the position that all the 8 judicial district court judges should be disqualified in this matter, because I'm investigating all of you.
Okay. All right.
I've been consistent.
Your delusions do not constitute malfeasance of the court. Just because you're crazy doesn't mean they're biased against you.
Let's see.
Thank you for the hype train, everyone. Much appreciated.
But the motion for release was to Judge Gregory or Judge Wilson.
The strike affidavits are all off calendar. Yeah, I have it. So, Mr. Blandino has indicated he does not want a ruling on the motion for release from GPS monitoring. This emergency motion to Judge Wilson is off calendar. Then the motion to remand the defendant and or any of...
Oh, Jesus. Green Guy says, bias reminds me of the word bi, which reminds me of femboys, which reminds me of 9/11, and makes me sad that Flight 175 never called them back. We're not doing femboy 9/11 today.
Additional conditions of release that has been...
If you don't know what that is, you should be very thankful. It's a YouTube video.
Denied. Mm-hmm. And then there's... I don't know why this got put on so many times, and there's state's notice of motion to remand.
Judge. I just need one more ruling for a motion to strike affidavits.
Yeah, that can be taken off calendar.
And then calendar call.
All right. Okay, so we are on today for calendar call as well. Is the state of Nevada ready to proceed?
They can be ready to proceed, Your Honor. We have subpoenaed the case. We've issued our notices. We were in a position earlier this week where we believed that the trial had been vacated as a result of the most recent motions to disqualify. So as a result of that, we had taken a step back from further preparing for the trial, but I think that I could determine whether it's possible based upon witness availability to go forward next week.
Okay, how long do you think it will last?
I mean, the state's part of the case would probably last about 2 to 3 days.
How many witnesses?
I'm guessing that we would probably have...
We should never watch Femboy 9/11 again. It's so much worse than Danzy ever was. I wonder how Danzy's doing. We haven't looked into Danzy in a long time, which is probably for the best. But I'll disagree with you about Femboy 9/11. That's one of the greatest pieces of postmodern art I've ever seen in my entire life. And I'll stand by that.
6 to 10.
When I die, put a QR code on my grave site with a link to Femboy 9/11.
10 witnesses maximum.
Okay. Thank you. Mr. Blandino, are you ready to go to trial next week?
As I already stated, and I've been consistent on this point, I want to stay pending. I demand my speedy trial.
It's already been denied. This is what he does. He just brings up the same motion, even though it's already been denied. He just thinks if he asks enough, they're going to relent. It's ridiculous.
You said by my actions previously that I waived that by my own actions, but I don't want a speedy trial. I don't want to have a speedy trial before a judge who has prejudice such as you do. And so therefore, I ask again for the stay pending an emergency writ to the Nevada Supreme Court, because I don't want to wait 20, 30 years like Annette Chivaria and Rippo and Carlos Gurry and now Bollinger now to get a trial and say, oh.
You are the only thing holding this trial up, sir. We're all looking for the guy who did this.
Yes, Judge Levitt and the 8th Judicial District, they should have disqualified. So now Mr.
I'm going to ask you a question again. Are you ready to go forward with trial next week?
I need to do an emergency petition to the Nevada Supreme Court. So in that light of that,
Whatever you want. Are you ready to go to trial?
no, and I've been denied, just for the record, so that you know. Drew Christensen hasn't got back to me. I've interviewed 3 times with Colette Putnam, who's a private investigator, that Drew Christensen approved funds, but I need investigation, and Drew Christensen's office is not calling me back as to the funds for investigation of witnesses. I'm going to have to call myself, if this thing is forced to go to trial, call myself as an expert witness. I know the DA
You cannot call yourself as an expert witness.
is going to raise a fit about that.
You're
and-
entitled to testify if you want to testify.
Oh, no, testify as an expert witness.
An expert in what?
I'm an expert in my own religious beliefs after studying comparative religious beliefs.
I'm an expert in my own religious beliefs. Beautiful. No notes. Rick M, thanks for 130 stream streak, says Kim should be sentenced to need to watch Femboy 9/11 1,000 times.
My religious beliefs are what motivated the conduct that the district attorney finds criminal, and which is no means is criminal. So I can testify as to Mr. Blandino, religious beliefs, how they've been developing and evolving over the years. And
I don't why do you think that would matter? Your motivations are pretty irrelevant here. Green Guy says, when I was at the store, the lines were so long. My recommendation, don't go to the supermarket today. Don't go, Kathy, don't go. We gotta rewatch SOS at some point. That shit's great. Gitara says, what religious belief is he an expert on? As a cleric of Paul, I'm also an expert in religious studies. He's an expert on his own batshit narcissistic version of Christianity that's all about God choosing him to be the most specialist boy.
And how that his main belief...
I'll have you know, by the way, when we actually get to trial, which we almost certainly won't get to today because there's so many videos of this guy, when he testifies, they tell him to keep it brief because, you know, he tends to opine. And I shit you not, they tell him to keep it brief, and he literally starts his story with his own conception. He literally starts opining about, well, I was born in such and such. Well, technically, 9 months before that, because life begins at conception. It's a lot. It's a lot. It's a lot.
Is not to do crimes, is not to do anything that he would not want anyone else to do unto him. And so therefore, to say...
That's like the most common religious belief in the world. Like, most religions and philosophical beliefs have some element of do unto others as you would have others do unto you. That's one of the most common human moral principles. You aren't unique for that.
That he had any specific intent to extort is beyond ridiculous. That Mr. Blandino was only trying to resolve a dispute as to the Commission on Judicial Discipline.
There was no dispute. He literally was a judge that ruled against you, so you tried to extort him by pretending to be part of the Commission on Judicial Discipline when you're not.
Filing. And following the same metric as what you yourself did in the Rita Dotson method. You stipulated to discipline, and I used those as a template. Judge Wanker.
Blandino, I got it. You want to call yourself as a witness, so I'm going to ask you one more time. Are you ready to go forward next week, or are you asking for a continuance?
I'm not asking for a continuance. I need to file a number.
Then we'll go forward next week. If you don't want a continuance, then we go forward.
Okay, without waiving my right. No, let me make it clear. Without waiving my right to a speedy trial, I will waive certain amount of the time it takes to do a petition to the Nevada Supreme Court, and in that regard, I am waiving the time, but not the...
Just a Peach with a tip says, reminder, he lives with his mother for most of this and tries to use that as a way to delay stuff. Oh, God. How did I miss that? He's living with his mom? I'm surprised his mom's still alive. Jesus Christ.
Speedy trial
She
right.
must look like that mom in the chocolate episode of SpongeBob that's just like a head and a spine.
And I think I have the right to do that. The case law all says that time is told. And you can still maintain the right, but the time is told. And that's what I'm asking for.
I don't know what that means, time is told.
It means that the time, in other words, if the delay is caused by the other
Jade's proxy says it wasn't his mom. He was the caretaker of an old lady. Okay, that's different.
actors, the other side of the case, then that is charged not against the defendant. If the defendant makes a motion, like if I do a pretrial writ of habeas corpus, then I would have to waive that time that it takes, and you still have the invoked right. So the time is told. It's pretty clear in the case law that you can still maintain the right, but certain time is carved out so that time is charged against the defendant, this time is charged against the state. And so that's what I'm looking
It's pretty clear that you are not ready to go to trial next week and that you want the court to continue it. So I can continue it for a short time. I don't know, Mr. Dickerson, do you want to be heard on his request to continue the trial?
So, I mean, we're ready. We can be ready to go next week. If we're going to continue the trial, I would just ask to discuss dates with the court.
We're looking at
Yeah, the prosecution's fed up, which I totally get. She's not controlling the courtroom at all.
Judge, there's another issue that needs to be resolved. As soon
I want to say she's a judge. I'm not. So she knows more than me. I completely respect that. It's fair. I just can't believe she lets him get away with as much as she does.
I have an absolute objection to the district attorney being the prosecutor because Steve Wolfson is a precipient witness. He helped me in my investigation. He found a judge that was not wearing, didn't have the name tag on there. And this is just a month or two before these charges were brought. I demanded to get that guy's name, and Steve Wolfson helped me investigate and found out who that judge was. And I, in turn, sent a letter similar to what I did with Federico, demanding that he be either apologize.
Depraved Ambiance says, no, Hannah, you're allowed to criticize judges or any other professional who's bad at their job. I don't want to come off like a sovereign citizen or someone like Kim Blandino who acts like they know the law better than actual lawyers and judges. She knows more than I do. She has experience in the courtroom. I do not. I'm just some random bitch on the internet. I just wanted to make it clear that I am aware of that. All that.
Forward with something to the Commission on Judicial Discipline. So I'm going to have to call Steve Wolfson as a witness in this matter, as well as Michael Dickerson and Melanie Marlin as witnesses in this case. So I think I sent a notice on this and I sent the proof.
It's irrelevant. All of that's irrelevant, Mr. Blandino. You need to stop.
Mr. Blandino, I'm going to tell you, just because you say you're going to call a witness doesn't mean you're going to call a witness. You're not going to call me as a witness. I have nothing to do with the underlying extortion and impersonation of an officer. Any testimony I would give.
But he wants to litigate his personal grievances against you. Why won't you let him live his fantasy?
Would be completely irrelevant. So again, it appears as though you're going down a path where you're going to refuse to follow the rules. So I have September 13th available. So it would be about a 30-day continuance.
It's real bad for me right now. All the way through November is very bad. I would ask for something in January.
Yeah, he has multiple, murder and assault trials going on at this time. Can you imagine how annoying it must be, him having to take time away from those serious cases to deal with Kim Blandino? What a waste of time.
I think that September I have trials, one on the 7th, one on the 13th, three on the 20th, one on the 27th. And we're talking very serious trials, most of them, several murder trials, multiple shootings.
Okay, how about December 6th?
I can do December 6th.
Okay, Mr. Blandino?
I'm sorry, you want me to say what?
Is that date okay with you? Are you paying attention? You're in court. Probably a good time to pay attention when you're your own attorney.
I'm inclined to set the matter over to December 6th. I'm just asking if you have any objection.
Well, I do have objections still with you proceeding forward. I just
All
that
right.
clear.
Again, Mr. Blandino, we are not, I am not going to do this every time. If you continue to challenge the jurisdiction of this court after 4 motions to disqualify have been heard and denied, you're going to leave me no choice but to revoke your self-representation. Okay? And then what's going to happen is I'll appoint an attorney, and then you will not be able to talk ever again in court. Do you understand that?
Well,
Is this the case where the original prosecutor sadly ended his own life? I thought that case happened with Blandino at some point. I know it's a Nevada case. I know this prosecutor makes it all the way through this trial, so if it was supposed to be during the trial, then it's not this one.
yes.
It appears as though you
That's also very sad.
have heard and you seem to understand.
Which person is the standby attorney? The person sitting next to Blandino.
So I'm
Okay.
going to vacate the August 30th date.
Well,
The
December.
September 2nd date can be vacated as moot, and we will set the trial over for December 6th. And then the calendar call will be,
Calendar call is going to be November 30th. That's going to be at 12:30 if we're still on pandemic schedule.
okay, go ahead. Did you want to say something else?
Is you talking
Even more. He hasn't talked enough, clearly.
to me, Jeff?
Yeah, it appeared as though you wanted to say something. If you didn't, that's okay as well.
You didn't
Yeah, a little reminiscent of Daryl Brooks, at least in the terms of, like, not listening to the judge.
ask for what my side of this trial. I intend to last about. It's going to take about 3 weeks.
Okay.
He thinks it's gonna take 3 weeks. I think it takes 10 days. Let me look. It might not even be exactly that many days. It's 10 parts on YouTube, but some of those are days split up and they have recesses in the middle of the day. It doesn't take 3 weeks, let me tell you that.
All right. So we have it set to go December 6th. We'll have the whole month.
Okay, that's it.
Okay.
Judge.
All right. Thank you very much. And again,
He's trying to
thank you
talk.
to both
I will-
sides for your patience. I apologize that it took so long to get to this. So thank you very much for being so patient and courteous.
Thank you, Honor.
Thanks, Jeff.
Thank you.
All right, before we get into the next video, I have to use the bathroom real quick, which I haven't had to do in the middle of stream in a while. So I guess we got to do the bit again, where I pull out a random Blu-ray. While I'm gone, Cher will tell you about Time Slip, the complete series. That's kind of a deep cut. All right, I'll be right back. Ugh, I'm back. Where'd this go? All right. Next hearing.
The last thing we have on this morning is State of Nevada versus Blandino. Do we have any appearances?
Judge, this is Kim Blandino appearing pro se for Kim Blandino. I'm on Ben Bateman's computer. That's why it shows that. But he's at CCDC, and he texted me that he'd like to trail, if that's possible. I guess we're the last item on the calendar.
You are the last item on calendar. Do you have any idea when he will be available?
I just texted him just a minute ago and let him know the proof.
Does the standby attorney luck out and not have to be his appointed attorney? I think the standby does get appointed as his attorney, unfortunately.
I didn't think a prove up would be that quick. So that was just 10.
Unless I am thinking of another case, I think they also attempt to withdraw at some point, and the judge does not allow them to withdraw because the issues he's having with Kim Blandino would be had with any attorney. So she basically says, no, you gotta be his attorney, sorry.
23. And I said to text me back as soon as he was out of CCDC. So, you know how the jail is. They're very sensitive about having cellular phone.
Oh, nice, Chromatic Cuttlefish. Glad you had fun. The Cameron arrest stuff from Van Balian, I believe that was an old arrest. So that he was pulling up an older Cameron video. Let me double check. But I'm fairly certain we covered the video that Van Balian did. Yeah, that was already one that we had covered before.
Phones there. So, that's all I can tell you at this point.
Well,
Which means I actually got to a Sobsit video before Van Balian, which is rare, because normally Van Balian's the first person to catch him.
I want to make a record, and I saw these filings. Have you seen this filing at 9 o'clock and then 9:18?
My law clerk saw it this morning and gave it to me, yes.
Yeah. So I do want to make a record, but I think it's only fair in the fact that he's court appointed and he has all that paperwork and stuff, and he wants to earn his pay, that he should be allowed to be here before any records made.
My birthday is the 12th, March 12th, which is coming up. I'm excited for my birthday.
Certainly. I don't want you to have to appear without him. So, but logistically, you can stay on the line. They can bring me back to the courtroom as soon as he's here.
Fine with you, it's fine with you.
Good enough. All right, so then we'll be in recess until the matter's ready to go forward.
Okay, thank you, Judge.
Thank you.
Hello, clerk, can you see us? Ben's logged in now.
Richard Efron's always
Okay, we'll go get the judge.
Let the judge know they're ready. Thank you.
Ben, can you hear me?
Yes, I can hear you.
Court is back in session.
Thank you, everyone. I'm going over to the case of State of Nevada versus Blandino. Appearances, please.
Kim Blandino appearing pro se for Kim Blandino, and I just need to state that I object to the blue jeans. I want to be there, but they won't let me in without the mask. I object to that refusal.
So noted. Other appearances, please.
Good morning, Your Honor. Ben Bateman, bar number 9338. I'm standby counsel for Mr. Blandino.
Thank you. Mr. Blandino, your motion, please.
Well, here's the problem. At 9 o'clock, there was an order issued by Linda Marie Bell.
Jesse asks, just got here. What is this pertaining to? The fella on screen here, Kim Blandino, is one of the most annoying defendants ever. We're watching a bunch of his court appearances.
This was to assign the motion to disqualify yourself to be heard by Judge Christina Silva. 18 minutes later, I stress that, a order denying motion to disqualify yourself was filed by Christina Silva. That's 9:18. I mean, just my printer doesn't work that fast, let alone typing up that. So the problem we have here, and I've stressed it all along, and that's why in the title of my motion to disqualify you and all the 8 Judicial District Court judges, is that there's been a conspiracy here, and I don't use that word lightly.
The last refuge of the narcissist, the conspiracy theory angle. I can't be doing things wrong. I can't be doing wrong things. Everyone's out to get me.
Press under color of office to just absolutely ignore the provisions of NRS 1.235. Judge Bell has no authority to assign Judge Silva. The statute is clear. It says, once a motion...
Did he really say dismiss all the judges? Yes, he wants every single judge in this district to recuse themselves from his case. He's still not given a good reason other than he perceives himself to be someone who investigates judges, so he thinks they're all out to get him because he thinks they think he's going to reveal all of their corruption. It's all in his head.
To disqualify is filed, and you, let's say in this case where I move to disqualify you, you have two choices. You immediately transfer it, or you move to challenge it. Now, I did get your affidavit that you filed in response, and so you chose to challenge it. You did so within the 5 judicial days required by the statute. However, the statute absolutely mandates that the matter is to be heard by a judge agreed upon by the parties, and only...
Oh, look, the same exact arguments he used in the last hearing with a different judge. Again, he's like the example of doing the same thing over and over again and expecting different results.
If the judge, the parties cannot agree, which is you and me, and I'd like to note in that regard that we are the parties to this action, and the district attorney is not here, and that properly not so, because this is a collateral action, not really a part of the criminal case per se.
Unstable Deadbeat says, why doesn't he just reveal all of their corruption? Wouldn't that get them taken off the bench? Hypothetical question, I know it's all bullshit. Yeah, it's almost like he doesn't have anything.
Hey.
They're all corrupt because they won't agree with him.
So,
and obviously he's always right.
This thing about... I'm going to read directly from 12356. The question of the judge's disqualification must thereupon be heard and determined by another judge agreed upon by the parties, or if they are unable to agree by a judge appointed. Now, you know, as a civil judge with I think you have a strictly civil calendar, that this entire judicial system in America is built on party...
This is a criminal motion, though. This is a motion in a criminal case. She must handle criminal stuff because this is a criminal matter.
He's trying to come to an agreement, either on a criminal case or a civil case, that it is dependent on parties trying to resolve the difficulties without going to court, because if nobody plea bargained or made civil settlements, you couldn't handle the caseload. This, in that spirit, is to get us to agree upon a judge to hear the matter of disqualification. And this is why there's a conspiracy to oppress under color of law. All you 8 judicial district court judges, without exception for decades now, from Chief Judge Togliatti to Chief Judge Barker to Chief Judge Gonzalez to Chief Judge Bell, ad nauseum, going backwards, has decided, well, we're going to let the Chief Judge hear all of these, and we'll just ignore all these deliberate...
Someone named Kim Blandino 8461 is in YouTube chat. Hold on. Let me look something up real quick. Kim Blandino 8461. He does have an actual YouTube channel, so I'm checking if this is the actual Kim Blandino. Oh, this is just called Kim Blandino. Oh no, it is Kim Oh no, Kim Blandino's in chat. Oh fuck. Well, there it is. Hello, Mr. Kim Blandino. We're enjoying some of your deranged court appearances. How are you doing? Don't cuss. You don't have jurisdiction in my stream, sir.
By the legislature. You, as judges, are required to follow the law. You cannot...
Kim, why did you kidnap your children in the 90s? That's not very cool.
Make law. And if you keep on doing this kind of thing, you undermine every...
Does your ex-wife still have a spiritual cancer?
Decent person's respect for the judicial branch of office. And, I mean, it's just absolutely clear. So there has to be, in my determination, of course, this particular aspect hadn't been adjudicated, even though it's been referenced in the case law. As to the judge...
Violation of custody rights was the charge. Right, but colloquially you took your kids when you weren't supposed to, correct? I'm not an actual judge, despite the costume. You don't need to be official with me. It doesn't work in court for you anyway, so.
Agreed upon by the parties. Now, of course, in judicial districts where you only have one or two judges, often...
Also, Kim, do you just, like, Google or YouTube your name every day? How did you find this stream so quick?
Times, you don't have a choice to a different department. Just because
I turned down a misdemeanor plea bargain credit for time served one day. I'm not asking about the legality. I'm talking about the immorality of you taking your children when you weren't supposed to and telling them that their mom has spiritual cancer, which is insane.
The choice here doesn't mean you don't have to follow the law as written. The legislature has testimony of experts. They get people in from other states and say, how can we make the best disqualification procedure we can? And then you, 8 judicial district court judges, want to subvert it and say, no, we're just going to go straight to the chief judge. I want it on record that I never have waived this provision and never will, because I've got a right to procedural as well as substantive due process. And this is one of those procedural due processes designed not only to streamline the process when a motion to disqualify is filed, but to make it concordant with all of our American jurisprudence, where if I've got an argument against you for bias, prejudice, or implied bias, or the risk of bias under Rippo v. Baker, then we get together, we agree upon a judge that will be mutually agreeable to hear the matter of the disqualification, and not to just run over me like a steamroller, which is what's being done here. I mean, to have Judge Bell run right over that thing again. Now, this is not the first time in this case that this has been done. And Judge Bell was the one that asked Justice Hardesty for Judge Wilson. I'm sorry, first Judge Gregory, and then Judge Gregory had to self-disqualify, which was laudable on his part. He had every reason to self-disqualify because he's a member of the Commission on Judicial Discipline, and he's a witness or a counsel to the witness, Paul Dyla, who's a complaining witness on the underlying criminal matters. So then Hardesty reassigns it to Judge Wilson out of the Carson City Judicial District. So then for Judge Bell to now come down, and Judge Bell, by the way, has disqualified herself in all matters here because there's an unadjudicated motion to disqualify her coming from a separate case, which I've noted in the record.
Again, he files like 18 motions to disqualify in this case, and none of them go through because there's no basis for it.
But you never follow through with it. I mean, this is just ridiculous that you don't want to follow the law and you want to just step over people's rights. And I'm serious about this, and that's why I filed this information. This is a conspiracy to oppress under color of office. The district attorney has now tried to coerce me under deprivation threat of not being able to see my son. So far, they've been able to carry that out, and I haven't been able to see my son that's in Davis, California. I've got no judge to make a motion to. And the Supreme Court is just sitting back waiting for me to waive my argument as to the disqualification of judges and make a motion to you or to one of the other judges that I'm not trying to disqualify, to undercut my argument. And I will not be tricked nor bullied.
Steve with a Q with 50 bits says, I think I see why he thought his side would take 3 weeks. This man could make fast food order into a 3-volume series. He likes to talk. He likes to talk.
Into waiving my rights. And I will not. When the legislature goes to all this time, this statute has been amended, 1.235 has been amended, first added to our NRS in 1977, then amended in 79, amended in 1981, amended in 2011, amended in 2017, 2013, 2017.
I'm not sure if he filed with... I don't think he would file directly to the Supreme Court. He probably meant the Supreme Court of Nevada.
17. Judge Gonzalez, in fact, as presiding judge at the time, lobbied to get the 2-day requirement to answer to 5 judicial days. And you, Judge Alf, already previously in this case, as I documented, you violated that provision. And when I first moved to disqualify you some months ago, you filed your answer in 6 judicial days. So you're outside, you defaulted. And that's when subsequently Judge Bell assigned a judge from another district. But now, see, you're trying to cover your tracks here. It was proper that rather than assigning what Judge Bell did is she assigned Judge Gregory then Wilson to hear the motion to disqualify Levitt, thereby jumping over you and jumping over Jones. So now, at least she got a little bit wise, and I say that in a facetious sense, that she said, okay, well, I'm just going to assign Judge Silva here in this. I'm going to assign Judge Silva to hear the motion to disqualify you, which is following the proper chain. However,
this is quite an old video. I know, Kim, we're going in chronological order. You have so much content.
The reason why this is a conspiracy, you have to determine that this is a nullity just based on fairness as being a party to this motion to disqualify. The order denying the motion to disqualify you is a fugitive document.
We did watch one of your recent tantrums the other day, though, so that's good.
Entirely. Judge Silva in this thing, he says,
is he a sob-sit or something else? I wouldn't call Kim a sovereign citizen because he doesn't follow the usual sovereign citizen pseudo-legal stuff. He's kind of into his own personal pseudo-legal stuff. It's not like he follows the specific I'm not driving, I'm traveling thing, at least not to my knowledge from what I've seen. He has his own justifications that are religiously based because he's a religious fanatic, basically.
Well, you can't move to disqualify all the 8 judicial district court judges because they haven't been assigned to this case. So what happens? Judge Silva gets assigned by Judge Bell.
Can we show him Femboy 9/11? My inner shit poster. Why did you say that? Why did you say that? Why did you say that? I have him here. He's watching. I could make him watch Femboy 9/11. Oh God, no! I won't. I won't.
9 o'clock this morning, and I have absolutely no time between then and now to file a motion to disqualify Silva, who was just assigned, and then 18 minutes later does this order. I mean, is this not looking weird to you, Judge? This is crazy. So she said, well, you can't.
Kim is a good Christian boy. How dare you say I should show him Femboy 9/11?
You can't disqualify me because I'm not assigned, basically. So now I've got no choice. You've left me no choice but to file a renewed motion to disqualify you, and then a motion to disqualify Silva under this Judge Bell order. You can't short circuit the process by going ahead and saying, well, we'll just cut Blandino short by giving him no time. You did this before.
Bye, Kim. He's leaving.
This was done, and I got thrown into
that was fun while it lasted.
Crossing as a result of that, because Levitt transferred this thing to the competency court, which the Nevada Supreme Court approved of that process for the 8th Judicial District in Ferguson v. State, that they said, well, yeah, you can transfer it to a competency court, but not when it's a matter during trial. But they never visited the issue of could they transfer it to a competency court when the person is representing himself and the trial court judge has every opportunity to canvass that person that's self-represented, which Judge Levitt did. There was no reasonable doubt about my competency. If there's any reasonable doubt about my competency, there has to be every reasonable doubt about everybody's competency. And I say that not braggadociously, but humbly, because I've been studying the law for decades.
Humbly, I think I'm smarter than every judge in this district. That's not very humble of you. It's not very humble. Just because you call it humble doesn't make it so. It's a little bit like this isn't financial advice.
And I know enough about the charges, the nature of the charges, so on and so forth. And then, while motions to disqualify are pending, Judge Silva, Judge Marquis, Judge Hardy, and Judge Bell even sat in on this thing and moved to send me to Lakes Crossing. And so there is so much evidence of foul doing, wrongdoing, and dirty hands in this matter, and criminal wrongdoing, that I submitted a complaint to the FBI and along with that information. But now I see that I have no choice but to go to LVMPD and file for these charges under the Nevada revised statutes, which the oppression under color of office is basically the state counterpart to 18 USC 242 and 241, which is...
How does he remember the names of all these judges? He's obsessive. This is almost his special interest, is pretending to be a lawyer.
Violation of civil rights under color of law. It basically mirrors that. And so I don't have any other choice but to do that, because, I mean, you're trying to railroad me with this process 18 minutes after assignment, and then we get an order like this, and no time. You know, in law, it's well known that you can't surprise or ambush a party. Well, this is ambush by assignment of a judge with no opportunity to respond. If you have any fairness in you, Judge Alf,
You ambushed me by scheduling this court hearing.
you would have to...
Everyone knows I need to disqualify every judge.
Have to say that this order is entirely wrong, both in its timing, not to allow me, see, before, when this happened, when I moved to just disqualify Levitt, I was given prior notice of assignment to Jones, and I properly filed a motion to disqualify her. Then and she didn't answer within, I think it was a month or so, that she filed her answer. Way out of time. Way out of time. And then you filed 6 judicial days after you were served. Now, it's not my fault that you won't take any paper documents, and I see Silva complaining about, I wasn't personally served. Well, you're not taking any paper because of this stupid COVID hysteria nonsense. So I'm not responsible.
Is there anything he's right about?
For that. We served it. Ben filed it on his computer through Tyler Technologies and the Odyssey system, and we properly served the department. When I called up your law clerk...
The list says he's still here. I kind of figured he was going to lurk. It's
Deborah,
fine.
The other day, I'm sorry, your JEA, Deborah, and I said, did you get that? And she said, no, I didn't get it. So I immediately sent it back out to the law clerk, and this time he got it, apparently. And then you filed your affidavit very soon thereafter. And so, I mean, you did challenge it. You did it timely this time. But I think that has to bear the fact that you were in this case, jumped out, and then are trying to jump back in, again, is entirely improper. It violates even the NRS, because it says once you've appeared in a matter, you cannot reappear in the matter. And so I think that could qualify. Now, granted, that's an arguable question that might have to go to an appellate court. But it sure doesn't pass the smell test, in that you can be selected out. Judge Wilson, after Gregory, comes into the case, and then Jones jumped in once and then twice, and now you jump in again. This is entirely improper. You're trying to subvert what the legislature tried to enact here. Now, we don't have this kind of protection in the federal system. When you want to disqualify a federal judge, it's very difficult. But as you know, the founding fathers wanted...
As opposed to doing it in the state, which is Kim's very successful at, despite failing every time in this case to try to get judges disqualified?
50 different state, well, when they were doing it, there wasn't 50 states, but they wanted state laboratories to experiment on different things. So the state of Nevada is entirely free to set up a procedure whereby the party has tremendous rights. And it's laudable that the legislature through all these years sat down and did this process. And even so, I got to point to this provision here.
How long's he been going now? We're 18 minutes into this video and he's been speaking for most of it.
The timely filing of this, it has to be less than 20 days before the date set for trial or hearing of the matter. So Silva was assigned, an hour ago? And so by Judge Bell. So obviously I can't do A. And then B, not less than 3 days set for the hearing of any matter. 18 minutes is well within 3 days. And then, except as otherwise provided in this subsection of subsection 3, if a case is not assigned to a judge before the time required under subsection 1 for filing the affidavit, The affidavit must be filed within 10 days after the party or party's attorney is notified that the case has been assigned to the judge. So with this Bell assignment of Judge Silva, I have 10 days to file.
Is this like an opening statement? I'm confused why he's getting to talk so much. It's basically a motion.
But
I don't know if he'd call it a motion, but he's basically making a motion.
you guys monkey with that. And when I say you guys, I'm referring to the 8 Judicial District Court judges. All of them in entirety, because I haven't seen one that has done this properly in my investigation.
All these judges say I'm wrong legally. They must all be corrupt.
Going over years and, in fact, decades. I filed my first motion to disqualify against Judge Jansen. He didn't file his thing within 2 years, back in 1986. And then Judge Earl White issued a writ of mandamus, granting me my relief because he didn't follow this statute as it was back there in 1986. So my only choice then is to file a renewed motion to disqualify you.
Overthought says he's done it. Kim has perfected the perpetual motion machine.
And then a motion to disqualify Silva, who has been assigned. And so, I tried to do everything within the rules, within the statutes, because when Judge Wilson said that you had some factual difficulties in filing against Judge Levitt, he denied the motion to disqualify and then dismissed it. But he did not dismiss it with prejudice, so I filed basically additional facts to cure it, and then
Gothgeek Gaming says, just curious, have you followed the TikTok Tarot trial? The one that's accused of defaming a University of Ohio professor? She's pro se and her trial is weird to say the least. I think I've vaguely heard about it, but I have not followed it. Is she the one who, even though, court orders told her to stop, she continued to levy accusations against someone? Yeah, I think I vaguely heard about it, but I've not followed it. That might be good for a true crime watch to cover at some point.
And what happens? Judge Jones jumps in and does it. In American jurisprudence, the right to file for reconsideration or a rehearing, because you judges aren't perfect. Just because you sit on the bench doesn't mean you're...
Great, then appeal the decision. But you can't act like your appeal went through as soon as you file it, because your appeals are probably not going to go through.
Perfect. You know that. I know it shouldn't have to be said. But you're not perfect, and you're not God. So you make mistakes, and sometimes...
Unlike Kim Blandino, he can't make mistakes because he's Jesus' special boy.
Judge is humble enough, they can correct their mistakes. Now, my view, humble judges are like hen's teeth these days. I saw your private proceedings, and I have to applaud you. I think you handled your calendar well before I came on. You seemed very measured, very temperate, and everything, but...
half of your home.
So forth. You've been road. When the rubber meets the road, the question is, are you going to follow this statute now or not? Now that you've been properly admonished as to what the statute reads.
You've been properly admonished. Quite a strategy to try and admonish the judge. How'd that work out?
And what it calls for. There's a lot of case law on this. Rippo versus Baker, that's another thing that's so flawed in this. Judge Silva never addresses Rippo v. Baker, Echeverria, or even really properly Rule 2.11, which is the standard now. It doesn't have to be actual or implied bias. It has to be the intolerable risk of unconstitutional bias.
Right, but just stating that you think there's the intolerable risk of unconstitutional bias, you have no basis. You're just claiming it because you perceive yourself as someone who's investigating the judiciary, which you have no qualifications to do or any official capacity. You're just a crazy person. That's not how this works.
That's what was established in Ripple.
This is literally why he got in trouble, was because he was claiming to a previous judge that he extorted, that he was, affiliated with a judicial watch group, which he isn't. He's not. That's another part of the charges he gets found guilty of here.
Oh.
And he's still basically doing it.
Well, none of you in your thing have even recognized that. So you're not following the case law. You're leaving it to the Fed.
Green guy says, hey, Hannah, I gave my dog a bath and showered myself. What did I miss? Kim Blandino showed up in chat, so you missed a lot.
To do it on habeas. David Bollinger has a current pending case because of Judge Whitehead some 30 years ago because the DA moved to disqualify him and he didn't disqualify out. He's trying to overcome a procedural default. So we got Echeverria and his co-defendant Gurry, we got Rippo, and they've had to go to the federal courts to get you state courts to act right as it comes to these disqualification issues. Now, the important thing about disqualification and the risk of bias is that the courts acknowledge that there are going to be times when a judge who has no bias whatsoever, actual...
Green guy says, who? Nobody? I'm going to color now. The guy on screen. He showed up in chat.
...or implied, it's just going to have to step down to err on the side of caution or to make sure that there's not that risk. But you don't want to accept that and not even put it or address it in these orders. There's been some orders now by Villani, Jones, Wilson didn't mention it. Silva certainly doesn't mention it here. So I object entirely to this thing. You are as a party and as a lawyer, because right now, as of the time I filed that motion to disqualify, and since you're not even tied to the criminal action, unlike when I moved to disqualify Judge Levitt, Levitt is tied to the criminal action. She's the criminal court judge. So then, like Gregory didn't have any tie to the criminal case, except that he found he did by way of his being on the commission and a witness and counsel for Paul Dyla, who's the head of the commission. So he said, wait a minute, there is a tie here, so I have to self-disqualify. But you here have no tie to this criminal case. Therefore, you are obligated not only as a judge, but as your bar license, because you are a party in a
It feels like he could really condense this down into like 5 minutes, but he likes to vamp. He likes to look like a lawyer. He likes to use those $5 words.
Collateral action. This is a collateral action, and it follows. The statute, you see, follows that. This is what the law was all about. So when I file a motion to disqualify, it has to be verified under penalty of perjury. And then if you challenge it, or any judge challenges it, that has to be a verified answer. Therefore, these, I would argue, now the court has never addressed this exactly, this point, but these are pleadings in a collateral action. My motion to disqualify is a pleading. Your answer is a pleading, just like in a regular civil action under the rules, where there's pleadings, then there's papers and other motions. Now, this is its own separate thing, and you have every responsibility to sit down with me. I mean, sit down, I'm using that term figuratively, but to try and agree on a judge. Mr. Blandino, what do you have? You don't have, you feel that the 8 judicial district court judges are not proper? Well, let's pick one from one of the other districts. Should we go back to Wilson, or should we go to one of the other judges in the other districts? But you don't want to do that. And see, that is also important. And so with the procedural due process being violated, and the fact that this thing has gone on for decades, and this kind of thing, an order assigning Judge Silva, and then 18 minutes later, Silva comes up with a pre-drafted thing. I mean, this is conspiracy. The nature of this timing evidences a denial to deny me my rights. I've been denied speedy pretrial, and speedy trial.
You're the one that's causing it to go on so long because you're a psycho about masks and COVID stuff, and you keep using the same exact motions that have already been denied. You are the reason this trial went on so long, Kim. It's not the judiciary's fault. You did this.
Because of this, I haven't been able to file any kind of motions, even to alter custody.
Green guy says plants are fucking hot? Please don't fuck your house plants.
This ankle bracelet's been on me now for over 2 years. I don't know if the camera can see that. That's a house arrest bracelet. I've got serious issues regarding that. It was put on ever since I was in justice court. $50,000 bond now, even though I am absolutely no threat. But can I...
You're an annoyance.
a judge to motion to modify my conditions of custody? No. When Judge Levitt was at this last hearing at August 24th, I had a motion to modify conditions directed specifically to Judge Gregory or Judge Wilson to have my conditions modified pending the motion to disqualify process, because finally I had an apparent impartial judge. As it turns out, I didn't with Gregory, which he properly self-disqualified. So
I'm not joking. Listening to him so long has given me a headache.
you know, you guys would want, and you guys, again, the 8 Judicial District Court judges would love for me
Not a
to
bit.
make motions to you and then say, well, Mr. Blandino undermined his own argument. If we're biased, why is he making motions for that? So I can't even go see my son in Davis, California. This very morning, my birthday anniversary, 66 years ago, I was born this day. Ironic that we're going through this process on my birthday anniversary. You have one birthday, everything afterwards is an anniversary.
Is he seriously being pedantic about birthdays? That's not your birthday. It's the anniversary of your birthday. Has being this much of a pedant ever helped you in your entire life? Why are you like this? Why are you like this? People are aware it's the anniversary of your birthday. We just call it a birthday. Oh my god.
Excuse me for that technicality, but I was always attracted to the law because of its specificity and preciseness, and there's supposed to be justice and verdict, you know, and all these terms. Verdict itself means truth told. It comes from the Latin. And so we have all this high-minded things, but it's been perverted beyond measure. And even the simplest of black and white things, that if an average non-judge or non-attorney or non-privileged member of the elite were to violate these provisions, they'd be thrown in jail for contempt or some other crime. But you guys, you violate this thing, you know, just day in and day out, you violate this statute. It's just as Jesus said thousands of years ago.
Oh look, something that has no place in court. Religion.
You put grievous burdens on the people, but you yourself...
How long is this video? An hour. An hour. And he talks for all of it.
...yourselves won't lift a finger.
We're only halfway through this video.
...to lift the lightest of burdens. This is not burdensome to get a judge to find a judge agreed upon by the parties to go ahead and to determine the motion to disqualify. This isn't rocket science. The other judges and the other...
Do you think Kim has ever realized that because he lost this case completely, that every moment of research he did for this was a waste of his time? Like, does he understand that?
Districts, because they only have 1 or 2 judges, are required to follow that. Just because you have multiple departments in this jurisdiction does not mean that. If you want to change the law, what do? What do you tell us peons, us peasants? You say, well, go to the legislature and get the law changed. Now, Judge Gonzalez...
When was this video? This was in October 2021.
...did that. She said, well, there's 2 days to respond. It's not good enough. The judge could waive their right to challenge with 2 days, and they're so busy. So then you get 5 days. And then Judge Bell sits on the bench hearing these disqualification motions where either no answer is filed or it's filed way untimely, and she still rules on the merits. Just totally stepping on the legislature's neck. And I apparently seem to be the only one that wants to challenge this and to say, hey, look, this is the law. It's supposed to be ruled by law, not men or women. It's supposed to be a procedure that you know of, that you can follow. And this is why I went after all these judges for investigation for judicial corruption and misconduct. This misconduct.
Does anyone remember the episode of The Twilight Zone called 4 O'Clock? This guy reminds me a lot of that episode. It's basically about a guy who perceives everyone else as evil, and he's obsessive, and he, like, calls, like, people's jobs and claims they're communists to try and get them fired, and he's, like, obsessive about judging everyone else. and he has a plan, and he's like, at 4 o'clock, all the evil people are gonna shrink to 2 feet tall. And then, of course, in Twilight Zone fashion, at 4 o'clock, he's the only one that turns into someone that's 2 feet tall. The idea is that he is projecting outward. He is obsessive about the morality of others while never looking at himself and his own actions.
This very misconduct, this very violation of NRS 1.230, 1.235, as I said, has been going on for decades in the municipal court, in the justice court, and in the 8th Judicial District Court. Why even have the law if you're just going to do whatever you darn well please?
If you don't interpret the law like I do, you're a fake lawyer.
It doesn't make
or fake judge.
Any kind of sense. And I urge, as a party, whatever you can do, this declared...
That's a good call, Carpkosian. Snuggle that cat.
And say, Mr. Blandino, because I've got no...
Huge asshole with 40 bits in a clip. You knew what you were getting into with this stream.
Choice, Judge.
At least after the first 10 minutes, you must have.
I have absolutely no choice. The way you're trying to rig the game here, and I use that seriously, rig and criminally rig this game. And I'm using game, I'm not Judge Fine, former Judge Fine, who was removed from the judge. She flipped out when I said, Mr. Blandino, this is not a game. Well, you're treating it like it's a gamesmanship thing. This thing about how you're trying to deprive me of rights, and criminally so, leaves me no choice but to file a renewed motion to disqualify you, and then
oh wow, another motion to disqualify. The last 14 worked so great.
Renewed motion to disqualify Silva, who
it's like this is the only move he knows.
Has been assigned, and even though she's...
Kim Blandino uses motion to dismiss. It's not very effective.
This fugitive order, as it states here, I've got 10 days from the notice of the assignment. I didn't know she...
100% Kim is going to come back after stream and read all the chat messages. Almost certainly, if he isn't still here.
Was assigned until this order came through. I'm sorry, till Judge Bell's order came through at 9 o'clock this morning.
Stone Corbell with 100 bits says, gonna go with rock. Nothing beats that.
Only because I didn't leave the my home office.
Is that a Simpsons gag?
Too early. Did I look on the computer one last minute and caught this thing?
He needs to have this happen to him. I'm scared to watch this.
Basically, all you're asking for is a chance, and if they're not going to give you a chance, you're just going to dismiss them. If you don't like me, even though I put myself out there, then I'm done. And by that, I mean I'm not going to conversate with you. I'm not going to invest time. I think it's converse. Huh? Just say talk. I'm not going to talk to you.
I didn't get any kind of call. I didn't get any kind of text that said, hey, you've got an order that's in your inbox. And I object to that greatly as well. Because you're trying to do all kinds of different stunts that if a party came before you, Judge, and this kind of manipulation and trying to manipulate the process, you'd be rightfully outraged. There is proper procedure. There's notifying the party. We got safe harbor provisions that are impacted here. I mean, when you go to file for sanctions, you know that you advise, hey, you've been out of line here. You always have that because you're not supposed to surprise or ambush there. How in the world can you characterize this as anything else but an ambush? Judge Bell, 9 o'clock, issues the order to assign Silva, and then at 9:18, before I have a chance to file anything,
how can I file my frivolous motions?
Judge Silva has denied the motion. How could she even do this in 18 minutes? There has to have been ex parte communications between the parties. And your parties, because...
Or your filings are just terrible and incorrect, and they've already heard what a pain in the ass you are. I don't know what to tell you, man. I think people know of you. Especially in that area. Hydrate, will do.
Whether you like it or not, I filed a motion to disqualify all the 8 Judicial District Court judges. I anticipated this stunt. That's why when I filed a motion to disqualify Levitt, and I...
How the hell can a judge even respond to the nonstop points he's listing? He's basically gish galloping.
Moved to disqualify Jones at the same time. I didn't file a third motion, and it was only God that called me to do it that way. I was following.
Solus says, hey Hannah, I've been listening in, but I don't know this guy's lore. Is he simply, as he sounds, just an obnoxious old man wanting his way, or is there more to it? He has been involved in lawsuits and legal stuff for like 40 years. I think he likes to pretend to be a lawyer. I think it makes him feel special. He's also broken the law multiple times and been involved in court cases. He's just a bit loony. I think he's just a character. I don't necessarily think that he's like a mass danger to anyone. He's just a severe annoyance to the judiciary system.
In God's direction in that regard. So I held off on filing a motion.
Oh, and he thinks he's working for God.
Disqualify.
He thinks God wants him to do these things, which, like, man, that's not a very good argument for Christianity if this is what God wants you to do with your time.
You. Fortunately, I got advances, the notice of your assignment. You didn't do the assignment and then issue
His kids are adults now.
Immediately an order. And so I filed a motion to disqualify well within the time frame because I didn't have notice of your assignment until whatever the date is on the calendar. So I properly filed the motion to disqualify you. So I'm being tricked and tried to be tricked and bullied into waiving my rights and to be snookered by some kind of procedure here. And it is not appreciated in any way whatsoever. And I think LVMPD, I'm going to ask for a special prosecutor under the Constitution that of victim rights. I've become a victim now of this, a victim of this oppression under color of office and coercion. So I intend to invoke the new Constitutional Crime Victim Rights Act, which is in the Nevada Constitution 8A. I'm a victim, and therefore I'm going to do everything in my power to see if I can have a special prosecutor, because one of the criminal actors here is the district attorney's office. If I sign a guilty plea agreement, I can go get to see my son for 1 week and then get the ankle bracelet right back on. You can't tell me that's not coercion. They're deprived.
I would say plea deals inherently are pretty coercive. It's always interesting that they're like, has anyone offered you anything to take this plea? And it's like, yeah, the prosecution. Like, yes, that's the entire nature of it.
Me going to see my son, and they know I have no judge. I have no option. I've been to the Supreme Court multiple times. I just got denial in 6 hours. I filed an emergency petition to go see my son, to go down to Route 66 on my 66th birthday, to go 66 miles at 66 miles an hour with my older son down in Kingman. But I can't leave Clark County. So I had no judge to make that motion to modify conditions of custody. So I had to go to the Nevada Supreme Court.
Man, you probably shouldn't have made this court hearing go on so long then. You could have been done like a year ago if you just let it go to trial instead of playing your games trying to disqualify every judge in the 8th District.
Court. Put in an emergency petition on Monday.
2.5 hours, don't you have some housekeeping? Oh yeah, I did forget at the middle. It's not a big deal. But if you like the stream, first of all, like it on YouTube. Hit the thumbs up. I'd appreciate it. Hype the video, which is the thing on YouTube now. And if you want to support the stream, you can always gift subs, bits, super chats, memberships. You know the deal.
And they denied me yesterday after having it for less than 5 hours. I got a call and they said, well, they denied your emergency petition.
It's an emergency petition. Don't you want that to be handled in a timely manner? You'd think. You're just upset that they didn't agree with you. Again, everyone's corrupt, and he knows it because they told him no, and that's how he knows they're corrupt.
That's exactly what was done in my family court case back in 2001. Judge Ritchie wrongfully disqualified himself. I had no other district court judge. Judge Pepez was assigned out of Ely.
I'm sorry, are you upset that a judge disqualified themselves? You're trying to get all the judges disqualified. What are you talking about?
And so I had to file a motion to order Judge Ritchie back onto the case to get mandamus on there. Judge Pepez was acting out of Ely. 2001, they had to fax my entire family court full file, which is about this high. That's about 12 inches high. They had to fax it to him so he could have the records of the case. And then 3 months later, Judge Ritchie was ordered back onto the case by the Nevada Supreme Court by way of mandamus. But in the meantime, I had no contact with my kids because I had no family court judge. I was between the devil and the deep blue sea. I put in a motion to disqualify Pepez, to stay.
I'm sorry, why are we talking about your family court stuff that has nothing to do with this right now? This is just, did they just set this hour for his motion hearing just to, like, let him talk himself out? Or they just like, let's just have him get one hearing where he just gets to ramble and be mad and get it out of his system.
And he granted the stay. At least he didn't force me to get the stay from the Nevada Supreme Court. But he saw what the problem was. And I don't think to this day I would have got relief if it wasn't for the judicial economy aspect of the fact that going to Pepez would have made it extremely costly. So, I mean, you know, I am the injured party here with tire marks and spike marks on my back from all that I've been run over.
Oh, poor baby.
Like this. And then when I properly tried to resolve a matter with this complaining witness, Federico, outside the Commission on Judicial Discipline, then I'm charged with extortion. When I wanted an apology, I was set.
You also asked him for some money.
There was
and basically implied that you were part of a judicial oversight board that you weren't. So that was a lie. I don't understand how you don't understand why this is wrong. That's concerning. If you don't understand why that's crazy, congrats. You're crazy.
All the activity with the marshal and the LVMPD. So that I can be stopped from trying to get him removed as a temporary judge to the municipal court and then pro tem for the justice of the peace, because the guy's got a political pull. Couldn't even find an attorney that wanted to take this criminal case when I was first in justice court. Five different attorneys in town said,
oh, I can't imagine why. You're so easy to work with.
no, that guy's got too much political clout. No way I could go up against him, but it'd ruin my career. Michael Federico. He's Olson Cannon, one of the old established firms in town, established in 1961. I know I'm rambling here a bit, Judge, but you've got to...
A bit. 39 minutes into his hour-long rant. I'm rambling a bit.
Understand. You may be an unwilling...
And I'm a little bit into Blu-rays.
Unwitting participant in this, but I'm trying to give you to understand that I'm following the law, I'm following the rules. And then to have Judge Levitt, last hearing on August 24th, tell me that I don't follow the rules. Mr. Blandino, you don't follow the rules? This is just nonsense. I'm the one that...
You're not following the rules. You weren't following the rules. You throw a little hissy fit over the mask thing and not knowing how computers work.
It's following the rules and the statute.
Caesar Bishop says, I am the rules.
And because you guys don't follow it, you guys, again, the 8 Judicial District Court judges, don't want to follow clear statute that's been adjudicated now for years, although not on the specific points I've mentioned here, but it's a process. It's been established. It's not anything new. It's not novel. And then the recent U.S. Supreme Court case of Ripple v. Baker, the Ninth Circuit cases, Echeverria versus Filson. Those cases established. And then those were all originated here. Those guys had to wait decades, Echeverria and Gurry and Ripple, to say, yeah, you were right. That judge shouldn't have been on that case in the very beginning. 20 and 30 years later, they had to wait. So I have to fight tooth and nail to have it kept down here.
Has he ever considered he might be wrong? I don't think once in his life he's ever recognized any wrongdoing he's ever done. I've known people like this. It's a fucking nightmare. My dad's like that. Fucked up.
Wait for some federal court judge to say when I'm 90.
It's a narcissist thing.
96 years old. You know, Mr. Blandino, you really had a point down there. Yeah, you can have a new trial now some 30 years later. No. That doesn't work. You know, this is criminal. You guys have 8 Judicial District Court judges, you guys have notification. I got to point to Rule 2.111, or 2.1 of the Judicial Code. A judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. Now, I am a reasonable person. I've had a lot of people tell me.
What's your standard for reasonableness? I don't know if it's the same as the courts.
Me that. Granted, I've had a lot of people tell me I'm unreasonable and they hate my guts. But be that as it may, I think it's reasonable that under the circumstances, and I have to call judges as a witness. My good friend, Judge Steele, well, I consider her a good friend. She may just consider me an acquaintance. I've known her for decades, and she's going to be called as a witness. She helped me file and support my complaint against Judge Herndon, Justice Herndon, who was properly given a letter of caution, but not any formal discipline. So I don't have anything in record. And he called me an a-hole in open court twice. And now he's sitting on the...
I don't think that the court should do that. I've seen that video. I think that judge acted pretty inappropriately, to be honest. But frankly, I get it. We've all heard this guy talk for a while. You get why that might happen. But yes, I would agree that that was inappropriate for a judge to do.
The Supreme Court bench. But I got a letter of caution against him. The jury has to know these things. So she filed the complaint. Judge Levitt, back in 2009, I addressed this issue in open court on Drew versus Manpower. I think I gave the case site somewhere in there. I don't have it handy. But I spoke to this very issue, and she said, no, Mr. Blandino, we do it differently down here. We have the chief judge assigned. That's relevant testimony to the fact that I was investigating this kind of corruption way back in 2009 and before. So I have to call Judge Levitt. I have to call Justice Herndon, then Judge Herndon. Judge Baer, he got a letter of caution for improperly finding me in contempt. Judge Levitt, as well as the disqualification thing, she should have been removed in that Rita Dotson thing that she got disciplined for. She not only wrongfully put a woman in contempt and jail, Rita Dotson, who was the mother of a defendant in a criminal case, when she went before the court, she lied to the commission. There should be a zero tolerance policy. You lie to the commission, you lose your judgeship. But no, she stipulated to a reprimand. Again, that's the way the system is made out. You plea bargain. You can plea bargain with the commission and get a reprimand.
How are they still letting him talk? I'm telling you, I think they just wanted to see if they could let him get everything out in this hearing and see if it made him stop. It didn't, of course. But yeah, this hearing is just like an hour of him just rambling, just absolutely string of words, going from one subject to the other. It's insane.
Judge Bell against the Judge Potter when he did that improper stuff in that case, and she filed a complaint. He was publicly admonished. But this was done by stipulation. But when I go to try and get a stipulation with this Federico, I get charged with extortion. So, there are...
Probably don't ask him for money and an apology then after he rules against you. Like, that's extortion. He asked him, basically, I had these expenses because you found me guilty and I needed these things, so you need to pay me back. And also, you need to issue an apology because I'm affiliated with the Judicial Oversight Committee, which he was not. Lying about an affiliation to an actual agency, to an actual thing, while asking a judge for money because they ruled against you. That's extortion!
Amazing issues here, and the district attorney...
And the court, of course, finds him guilty of that.
Has no business not being disqualified or disqualifying themselves. Steve Wilson helped me find the name of a judge that didn't have their nameplate on. I see you got your nameplate on your bench. What do you think of a judge is routinely sitting on the bench with no nameplate on? So if somebody wants to make a complaint from the audience, they don't know. They got to do an investigation just to find out the name of the judge that's on the bench.
I don't think it would be that difficult to find out which judge is presiding over a specific courtroom that day. I'd imagine you could literally look at the schedule or ask someone at the courthouse who has, access to their schedule for the day. I don't think it would take that much work.
As a matter of fact, Judge Silva sat on the bench when Judge Bell's nameplate was on the nameplate because she came in Judge Bell's courtroom. So if somebody wanted to make a complaint against Judge Silva, they'd think it was Judge Bell. At the beginning, I have to say, you're not Judge Bell unless you got one heck of a makeover or whatever I said. He says, no, I'm Judge Silva. But this is some of the things that's going on. You know, I understand there's tons of laws. This state and the feds and everywhere is bloated thick with laws, and it's hard to know them all. But this one, it's very clear. The reason I copy it and paste it into my emotions is that so there can't be any excuse of what the law reads. I mean, it's absolutely clear. This process is just refined. I mean, so that even if you don't know of the assignment until the last minute, you still can file that motion to disqualify if some judge tries to ambush you. And I've been ambushed over and over again in this case. And I couldn't respond to that one ambush that happened in January with Judge Villani because I was in jail. I wasn't getting the notification that I can get there. I didn't get even notification of his order denying my motion to disqualify. So when Judge Silva goes through the litany of disqualification motions, you know, it's only because this has been...
Gitara with 50 bits says, you know what? Yes, law is hard. You know what makes it easier, Kim? A lawyer. Hire a lawyer.
This process has been perverted. All Judge Leavitt had to do was to guarantee my speedy trial, my speedy pre-trial rights, were to say, Mr. Blandino, well, I don't think there is a risk of bias here. You say you're going to call me as a witness. I mean, there wasn't any inquiry. Mr. Blandino, why would you be calling me as a witness? And then I could have recounted that in 2009, this very issue for which I investigated, the corruption as to this one, and I could have informed her. But she wasn't curious. Because why do you need to be curious when you don't, all you have to do is wait out the complainant 20 to 30 years until they get into federal court. You know, if you're not going to be held accountable, I mean, until 20 or 30 years, long after you're on the bench, off the bench. Judge Lehman in the Echeverria-Gurry case, long off the bench. Judge Bongiovanni in the Rippo case, I may have that reversed, but as Judge Bongiovanni is being investigated by the FBI, and now Judge Whitehead in the Bollinger case, which is...
Does he really think he's going to be around in 30 years to adjudicate anything? He's already like 66 years old in this video. He's like 70 now.
Federal habeas, that's 20-something years ago. These guys are long gone. They had the darn plea bargain agreement. He was negotiating with the FBI to leave the bench, and they wouldn't continue their investigation if he would voluntarily resign his judgeship with the Commission on Judicial Discipline, which he did. And so I don't know how long you've been in Nevada, Judge, or been aware of that, but that Whitehead case made all the papers. I mean, it was very big news. You had half the Supreme Court warring with the other half. And you had to, a mandamus had to be issued against the other half of the Nevada Supreme Court. And so, you know, you err on the side of caution with this mask and this virus, but you don't want to err on the side of caution here. You err on the side of caution with this competency things, and you even pervert the standard. It's supposed to be reasonable doubt that a person's not competent. There was no...
Yeah, it's pretty reasonable to assume you aren't competent if you listen to you for like 10 minutes.
Reasonable doubt about me, but Leavitt just sent me away. I heard Bell in open court on another competency matter saying, I'm sorry, sir. He was complaining because he was just found competent 2 months ago. And then another issue of competency was raised, and she said, I'm sorry, sir, but if there's any doubt, we have to refer you to psychological evaluation. Well, that's not the standard. The standard's not any doubt. It's reasonable doubt. It's reasonable doubt as to competency.
A person who is not necessarily competent isn't the best judge of reasonability. Do you see why you're a bad judge of your own competence? Like, you can't assume that your interpretation of reasonable in this case is the correct one because other people can see you more objectively. Obviously, you have a warped view of yourself. Everyone has a warped view of themselves to some extent compared to other people's perceptions of them, because we all have, you know, like an ego, and we all have self-perceptions that aren't necessarily true. But, like, yours is, like, crazy different from what other people perceive.
Here, we don't even have reasonable doubt. I mean, the statute is absolutely clear what's going to happen. But, you know, you want to err on the side of caution, but all you had to do, all Leavitt had to do 2 years ago, was there on the side of caution. Now Bill Terry, who was going to be one of my primary witnesses, one of the most respected attorneys by defense as well as the prosecution bar, has died. One of my key witnesses has died before trial because of this dragging feet and you're not following.
I guess you shouldn't keep holding up the trial then.
The rules here, not giving me my speedy.
Imagine holding up your own trial so long a witness fucking dies.
Pre-trial and speedy trial rights. So I got a 96-year-old witness that heard the complaining witness on the phone ask me to present some kind of settlement agreement as to my complaints about him with judicial agreement. And then when I submit it to his email, which he gave me, he goes to the DA. Somehow, I don't know how he got to the DA to file a police report. And then I get charged with extortion. These are totally bogus charges, but I've had no judge to address them to. No.
Again, he is convicted of these charges at a jury trial.
No judge to address them to. So, Judge, I know you've been very patient, and I could speak for another 3 hours.
Pain.
Honestly, I could. I got witnesses I got to bring in to testify to that. I think I've covered a lot of ground here. I mean, if you would like to ask any questions, I'll be happy to answer any questions on point. But I just, so that there's no surprise.
I have a question. Who hurt you?
On your part, if you don't do the right thing here, and the right thing here is to somehow say, I believe that this order denying motion to disqualify now for ruled by Silva was ambush, was surprise, and therefore I agree with Mr. Blandino as a fellow party to the motion to disqualify. But we're going to see if we can agree on a judge to hear this matter of my disqualification, if that's the way you want to do it. But if anybody that is serious looked at the record in this case, what I've had to do and how I've had to do it, and who's following the statute and rules and who's not, any objective person would say, yeah, there's no contest here. 5 days to answer. If you don't answer, you got to transfer the case. The intolerable risk. I mean, if I were an actual official, which I never have claimed to be one, if I...
Again, he is found guilty of impersonating an official in this case. Jitara says, do you think Kim thought the dead witnesses were on their deathbeds going weekly, oh shoot, if only Kim got a speedy trial, I could have done something righteous before I died. Death noises.
If I were an official working with the Commission on Judicial Discipline, and I announced that I was investigating all of the 8 judicial court judges in the conspiracy, there is no way that you would get a judge from another district. It makes no difference whatsoever that I'm not an official, that I'm doing this privately. You guys, and the 8 judicial district court judges, if you don't get off this case, you can put me away for 11 years and that solves your problem. You tell me how you're not an interested party. You tell me how there's not a risk of bias. I mean, because if you, because I'm coming, Levitt is my #1 target for getting her to resign or removed from the bench. Legally.
You can't manufacture bias by saying you're going after a judge, so they must have bias against you. That's not how this works.
Now, I'm not making any threats that are illegal or anything. But I'm telling you that this is just absolute. She should have been removed in that Rita Dotson thing when she lied to the commission. It's not my fault that they didn't.
He doesn't get that long on this. I don't remember what his exact penalty was when he's found guilty, but it was like a fine. It's barely anything.
A zero tolerance policy. What amazes me is how you have a zero tolerance.
He does end up suing the parole board after this, though. I'm not as clear on that case. I got to look more into it to see what that's about.
Policy, if some kid draws a gun in school, he's taken out and he's doing. But you don't have a zero tolerance policy when judges absolutely refuse to follow the law. What kind of planet are we on there? Now, I know it's hard to recruit judges and to get judges to run for some of these offices, and that's its own set of problems. However, you still got to follow the law. And just because you have a multitude doing the same thing doesn't make it right. The scriptures are absolutely clear on that. Thou shalt not follow a multitude to do evil.
Your religious beliefs are not relevant to court. Court is a secular process, ideally. You can't cite the Bible in court as if it has legal weight. It does not.
Or to wrest judgment. So, I just couldn't be any more outraged when I saw this thing 18 minutes after Judge Bell assigns, and where the heck is she assigning Silva from? She thinks because she did it once, she can do it again? I was in jail last time. I didn't have much means to do come back like I did. But now I do. I have the right under the law. I have to state this. I have the right to resist illegal acts. It's codified in the statute. I don't have that paperwork with me, darn it. But I have the right to resist criminal activity. And so this is part of my resistance here. Just because you do it under a robe, criminal activity, you're immune from civil liability. Absolutely immune, Judge, from civil liability, but not from criminal liability. And for misdemeanors, state court judges have been removed by the feds for prosecution under 18 U.S.C. 242 and 241 for criminal behavior. Judge Nally most recently. And
it's criminal to disagree with him and come to different judicial conclusions than he does, by the way.
Maryland wrongfully tased the guy with a stun cuff, and he lost his office, ordered anger management, $5,000 fine, and the whole kid.
I actually remember that case. I think it got covered on court TV at some point. It was really fucked up. You're not that case. You're not being mistreated. They are giving you so much leeway, Mr. Blandino. They are being so nice to you, and you fail to understand.
For that outrageous act. So I've got every right to resist criminal activity, even if it's done by judge. I don't know what LVMPD is going to do about my criminal complaint. I've got plenty of documentation that you and your companions on the 8th Judicial District has supplied me with. I've got the statute. But I cannot tolerate this. There are too many people that can't speak like I can, that aren't as articulate or know the law, that know something's wrong. It doesn't pass the smell test.
He's just so smart and knows the law better than any lawyer or judge.
But they just don't know how to articulate that. I owe a duty to them. Those are my neighbors out there. I'm very sincere about that.
Please understand, just because you know words and you can talk without end doesn't make you articulate. Being articulate also means being able to speak succinctly. Just because you can opine for hours doesn't make you articulate. You need to also be able to be reasonable in the amount of time it takes to communicate ideas. And I'm someone who can ramble. Believe it, I know. But he is not... Just because you can talk for an hour without pausing doesn't make you articulate. It makes you long-winded.
We're supposed to help our neighbors. You know the story of the Good Samaritan. Well, here, granted, it's Kim Blandino that's being beat up, but I know there's other people being beat up. I've seen them in court. Attorneys come in before Judge Bell on a motion to disqualify, and they haven't filed an answer. And I hear them talking in the gallery. Yeah, this only take 10 minutes because the judge didn't get any answer to the motion to disqualify. And Judge Bell's sitting there ruling on the merits. When there's a clear default, a willful and conscious default to file an answer. You didn't file, Judge, on that first motion to disqualify in 6 days. You've waived your right to file this one now, I contend. You can't get a second bite at the apple and then come back around on a case a second time. I mean, if
you filed the same motion like 15 times.
The disqualification provisions. You're in Department 3A, right? You apparently did this prior disqualification from 12, or that's what I think the records reflect. You can't even rule on this because under subsection 6D of Rule 2.
German Cow JJ, what do you want me to look up in Black's Law? Is it filibuster? Because I know someone else mentioned that.
1-1. The judge
Do I think he got the mental health help he needed? Probably not.
C was a material witness, or D.
He's still doing this stuff. The most recent videos of him are from like 2 or 3 weeks ago, so he's still doing this, so he hasn't learned anything. I'll look up filibuster real quick.
Previously presided of a judge over the matter in another court. So technically speaking, you already previously presided, in a sense, over this disqualification. You can't re-enter this case now again. You can't do it. Now, granted, that one may be a stretch. That's arguable. However, this intolerable risk of bias, this is not questionable. I mean, you guys are interested parties. If I'm free of these criminal charges, I've got all kinds of time now to investigate all the criminal.
Filibuster, a dilatory tactic, especially prolonged and often irrelevant speech-making employed in an attempt to obstruct legal action. The filibuster is common in the U.S. Senate, where the right to debate is usually unlimited, and where a filibuster can be terminated only by a cloture vote of 2/3 of all members.
Acts you guys have done to investigate your record on these motions to disqualify. Have you done this over?
Yeah, this guy showed up in YouTube chat today.
Over and over.
And everyone was very mean to him immediately.
Again.
Which isn't great. I didn't help the situation.
With parties where you don't go up to agree upon a party, but just let the chief judge do it. Oh, yeah, you'll be able to argue. Well, the party never objected to the chief judge, so therefore they waive the right. I'm not waiving anything. I demand that you follow the darn statute to the letter and the spirit of it. And so, I don't know how much time I've gone. I've
57 minutes.
Getting a dry throat now, so I gotta take a sip of coffee.
Yeah, I bet your throat's dry.
Mr. Blandino, I've listened very patiently. I read everything. You've talked for over 50 minutes, and I have a jury coming in 35 minutes. May I ask you to please conclude?
Okay. Well, again, I just have to point out that this assignment was improper. All of the process, everything I have stated, is valid. All I can
Everything I've stated is valid. The court assumes you believe that, otherwise you wouldn't have said it. That's not necessarily necessary to say.
now appeal to is your conscience. Now it appears, you use that term in all kinds of jurisprudence. It strikes the conscience of the court. Well, so they acknowledge that there's a real person rather than just a court to strike the conscience. I've been accused of trying to delay the process, and that's absolutely not true. The delay is a collateral consequence of what I've done, but only because
Sure, the delay is because of my actions, but it's not my fault. Hey, Jade Monkey.
The statutes have not been followed. The case law hasn't been followed. So I have to resist. If you go ahead and you sustain this process, or however, that sustain isn't the proper procedure.
Jade Monkey, thanks for 28 months, says good old Kim. Yeah, we're definitely going to have to do more episodes on him in the future because there's so many more videos.
But if you ratify this improper process that has happened, then I've got no choice.
We haven't even gotten to the first trial. These are still all the pre-trial stuff for the first trial that's online.
I'm just giving the court advance notice. I've got no choice to file a renewed motion.
And I skipped a lot of like stuff that didn't matter, where Kim didn't show up.
To disqualify Silva because I was ambushed with that. I mean, I just have to point out once again, at 9 o'clock, she was assigned to be heard, and 18 minutes later, she comes up with, what is this, with the service page. Oh, she doesn't have these even numbered. So 1, 2, 3, 4, 5, 6, 7, with the service pages, 8 pages of an order
So how is it he's not been declared a vexatious litigant? He has since this. He just hasn't yet in this case, but he has been deemed a vexatious litigant.
Denying the motion to disqualify 18 minutes after she's been assigned. This smacks of criminal conspiracy, Judge. So if
everything that's against me is a conspiracy.
If you don't object to this process, then I don't know if I got enough material together to go to LVMPD. I'm going to either go either today or tomorrow, or at the latest Monday. Hopefully, I can get everything together over the weekend. And in the meantime, if you do sustain this, then I'm going to file that renewed motion. Hopefully, I will. But whether or not I file the renewed, I'm still going to go. I have to make a record now and show good faith. I go into LVMPD and make.
It's funny that, like, previously the judges told him he was acting in bad faith, so now he thinks saying in good faith will cover his ass.
That criminal complaint, and then I'm going to put this additional information.
If I say it, it must be true.
To the FBI, because this is just a violation criminally under 18 U.S.C. 242. I've done everything I can. I've been very, very patient with all of you. Very patient. And so...
You've been patient with the court? Kim, the court has been patient with you. You're the most obnoxious litigant I've ever seen in my life. Like, do you perceive that you are incredibly obnoxious and everyone is annoyed by you in all of these videos?
I'll let the paperwork speak and I'll wait to hear from you. Yeah, but again, I sought to disqualify.
I'll let the paperwork speak after rambling for an hour.
You are a party to that action. As far as I'm concerned, you're still a party. And this, I don't know if I'm using the term correctly, but the closest I can come to it is I believe that this order is a fugitive document. It's an illegal document. It basically is a fraud upon the court, as well as judge's order. Because I sent her a letter, and I attached it to something. I don't know this. I sent a letter telling her that she can't keep doing this thing, and so she goes right ahead, willfully and maliciously assigns Judge Silva at 9 o'clock, and I have to believe she talked to Silva before she did this, and there was some kind of confab. This type of thing happened in that Marlon Brown case where she assigned a different judge, Judge Kosach, to hear the entire matter on his writ, because he had a problem with Marlon Brown had a problem with Judge Levitt as well. Levitt was going to be a witness in the case, and Judge Bell finally acknowledged that after years, that Levitt was going to be a witness, therefore it'd be improper for her.
Okay, she told you to wrap it up.
To stay on the case, and as a result, she disqualified the entire 8th Judicial District Court judge just from Judge Levitt being called alone as a witness. And so I properly, if you want any offer of proof as to why it's important to me to call Levitt and Judge Steele and the other judges, I can definitely supply that. I've been hesitant to get that specific information to Judge Levitt because there wasn't a written, signed, and filed order. And my problem is that there was a minute order referencing that. And so judges can go in there and you guys can erase, modify, and change entirely minute orders, even though they're decades old. And I've seen that done before. You can't get a certified copy of the minutes, from the clerk. And so in that regard, I'll let you go on to your other trial stuff. Thank you, Judge.
Finally!
Thank you, Mr. Blandino. I'll consider the matter submitted. I want a chance to think about things and re-review your papers. I'll set this on my chamber's calendar on the 19th as my reminder to make sure I get a decision to you by then.
Okay, thank you, Judge.
Court is now in recess.
Would you be surprised to know his motion is not accepted? All right. Okay. I think we're done for the day. We've been going 3 hours. I will save where we left off. And then sometime maybe next week we can do a part 2 to this and see stuff up to the trial and maybe some of his I'm blanking on the word. Man, I'm tired. Testimony, which is pretty crazy. So anyway, thanks everyone for hanging out. Let's see who's on Twitch that we're gonna raid. I appreciate people hanging out, by the way. I know that was an arduous one. I know that he's a lot. I know he's a lot, but I appreciate you guys hanging out and watching. Can we raid Javon? I don't know who that is, but sure. Javon. Which person? Because there's multiple people named Javon. Bradley? Jovan? Oh, I spelled it wrong. Jovan Bradley.
They have to be free and accessible to every single person.
All right. Have a wonderful evening, everyone. I'll see you tomorrow. Not sure what we're going to do yet. I still want to do that thing on the people who have AI partners and they're devastated about ChatGPT 4.0 being deleted. I don't know if we'll do that tomorrow or maybe tinfoil tomorrow. We'll see. All right. See you later. Have a good night.